of the Constitution to revisit the case of Zulfikar Ali Bhutto.
जी आज कौन आप हैं? जी सर जी. And you are for?
My Lord, I am for Ms. Anam Bhutto, Ms. Asifa Bhutto Zardari, and Ms. Bakhtawar Bhutto Zardari.
One daughter and two granddaughters.
That's right, my Lord. My Lord, before I start with my very brief arguments, which I have tried to compile together, if your lordships would just give me 1 minute to do a little bit of housekeeping for your convenience. My Lord, I have filed CMA number 1582. This is the mainstay of all my arguments, my Lord. It's based on 70 pages, and it deals with the 10 questions or issues, as my Lord Mandu Khel had pointed out in the recordic reference, that were framed by this honorable court in its order dated 12/12/2023. Out of those 12 issues, my Lord, I have addressed 7. So this is in CMA number 1582. Then, my Lord, I have also filed before your lordships. Filed just now, my Lord, paper book number 1. Paper book, I don't know whether it is with your lordships. It's with your lordships, my Lord. Paper book number 1 carries, my Lord, the transcript of the interview of Justice Retired Naseem Hassan Shah on Geo. It carries a CD and transcript of the excerpt of the interview of Justice Retired Durab Patel, which he gave to PTV and which was telecast by Dawn News. Then there is excerpts from the book of Hamid Khan, titled History of Judiciary in Pakistan, and this is an interview of the former Chief Justice of the Lahore High Court. Then I have given Black's Laws Dictionary, my Lord. Then there is a cutting of the New York Times, which deals with the removal of the Chief Justice of Pakistan, Justice Yaqub. Then there are 2 letters, my Lord, which Shaheed Zulfikar Ali Bhutto wrote on 7/5/1978 and 28/6/1978 to the Chief Justice of Pakistan, stating various reasons and asking him to recuse from the bench. These letters went begging, my Lord. Then I've also filed, my Lord, a report of the Convention of International Jurists on the trial of Shaheed Zulfikar Ali Bhutto, which was unfortunately held on the day of his execution, that is the 4th of April at London, which had leading jurists attending.
Where are the letters? I can't find them.
My Lord, the letters are at tab 6, my Lord.
It's on a plain piece of paper.
Yes, my Lord, these were written on a plain piece of paper.
No, it's not a photocopy.
These are photocopies, my Lord. These are photocopies of the original letter that
it doesn't have a signature or anything on it.
My Lord, it does.
Page 29.
I'm sorry, my Lord. Yes, it doesn't have the signatures, my Lord.
Okay, better copies.
This is a retyped version, no?
These are retyped versions.
You have the original version?
My Lord, I've done my level best, but I've not been able to get the original. The original was perhaps sent from the district jail.
Where did you get this from?
My Lord, from the old record that was present with Mr. Yahya Bakhtiar's daughter now.
Okay.
That was also in this shape.
That was also in this shape, my lord. It was in this shape that I have received and put copies, my lord. And then, my lord, there's the, at number 8 is the opinion of the House of Lords in the Punisher case. And lastly, there's the Sindh High Court Bar Association's case, my lord. My lord, on the last date of hearing, my lord, the Honorable, my lord, the Chief Justice raised certain queries and asked me to take those up. And before I commence the arguments, I would first try and answer the queries that my lord raised. And the question that, the first question that my lord raised was the names of the persons mentioned in the examination in chief of Masood Mahmood. The names are, my lord, Waqar Ahmed, Cabinet Secretary. This is at was Waqar Ahmed, my lord, Cabinet Secretary, Haq Nawaz Tiwana.
Just also tell us, was he produced as a witness?
My lord, in the next question.
No, keep telling us, Waqar Ahmed produced?
No, my lord, Waqar Ahmed was not produced. Haq Nawaz Tiwana, former DG FSF.
Haq Nawaz
Tiwana, my lord, former DG FSF. He died, my lord. Then Mr. Said
died at the relevant time he was alive?
Not at the time of the trial, my lord.
Okay.
Then, my lord, Said Ahmed, Chief Security Officer of the Prime Minister. He was examined, my lord.
Chief Security
Officer, my lord, to the Prime Minister. He was examined.
Examined as?
PW2, my lord.
Prosecution witness.
My lord.
And what did he say and did it?
Sorry, PW14, my lord.
And what did he say and did it conform with what Mr. Masood Mahmood had said?
My lord, he in actual fact was the main collaborative evidence that the prosecution produced.
Which one?
In fact, Saeed Ahmed Khan, my lord. He was the, or in fact, the only evidence that was produced to collaborate the statement of the approver, Masood Mahmood, my lord.
Is it they are the same in material terms or they are different?
My lord,
Mahmood's and Saeed Ahmed's statements.
My lord, they are not essentially same in material terms. The gist may be the same, but by and large they are different, and the very credentials of Saeed Ahmed Khan are also questionable. As
Saeed Ahmed Khan was a government servant?
Yes, my lord.
Grade?
Grade 21, my lord, if I'm not mistaken, my lord. My lord, if your lordship would see paper book CMA number 1582.
Are we done with the names?
No, my lord. Then we have Mia Muhammad Abbas, Director Operations of FSF. He was examined. He was co-accused and he was examined. Then we have Muhammad.
As what?
As
PW, DW?
He was an accused, my lord.
342.
Examined as?
At 342 iska hua tha, my lord.
He has not been examined.
Not examined.
He has not been examined. वो तो मुल्ज़म था जी.
जी मैं मुल्ज़म था, my lord. जी उसने बयान दिया under 342.
So okay, to that extent.
Yes, my lord, to that.
And what does he say in a nutshell?
My lord, he in a nutshell talks about how the operation was conducted and how
He implicates or exonerates?
he does not mention Mr. Bhutto as such. He talks about the orders being passed down to him by Masood Mahmood and how the operation or so-called operation then went on.
इस 342 में माना है. 342 में माना
नहीं
है?
उसने कन्फेशन
नहीं
में
सर,
माना
उसने
है
कन्फेशन में माना है,
और 342 में उसने डिनाई
उसने रिट्रैक्ट किया है माय लॉर्ड।
ट्रायल में ना वो एग्जामन हुआ ना उसने कोई ऐसा बयान दिया।
जी सर,
ट्रायल में नहीं दिया।
he retracted in 342
वो
my
तो
lord.
दे दिया, वो
जी
तो
सर,
special-
वो इनका 164 रिकॉर्ड हुआ था
वो इसका 164
और फिर वो रिट्राइड कर दिया,
जी माय लॉर्ड।
वो कोर्ट में उसने कोई ऐसा बयान नहीं दिया
रिट्रैक्टेड इन 342।
जी
पहले।
And then, my lord, there's Abdul Hamid Bajwa, who was assistant to the chief security officer, Saeed Ahmed. He also died. He was not examined.
Assistant to Saeed Ahmed,
Saeed Ahmed, my lord.
not examined.
Not examined.
He died during the trial?
He died probably prior to the trial, my lord. Then, my lord, there was
These people died of natural causes?
natural causes, my lord. I'm hazarding a guess on that, but what is believed is that they died of natural causes. Then there is Mr. Welch, who is Director FSF.
What's his full name?
Mervyn Rupert Welch.
What do you spell the first one?
MERVYN.
E-Y-N.
N, my lord.
G. R-U-P-E-R-T.
RUPER.
Rupert, not T.
Rupert. No, my lord.
Welch.
Welch, my
And
lord.
he
WELCH.
And he was?
He was, my lord, Director FSF Quetta.
And what is
He was PW4, my lord. He was examined,
PW4?
my lord.
And what does he say?
My lord, he talks about the time when a delegation of the opposition went to Quetta, and Mr. Kasuri was there, and he was told that he is to be looked after within inverted commas, and eventually nothing transpired and nothing happened, my lord. That's the gist of his deposition. And then, my lord, there is Riyasuddin Ahmed. Riyasuddin Ahmed. He was Defense Secretary, my lord. He was not examined. Then there was mentioned is General Fazlim Mughis. He was also Defense Secretary. He was also not examined.
General?
Mughis.
पूरा नाम क्या है?
General Fazl Mughis.
Mughis.
Mughis, my lord. Mughes.
Not examined.
Not examined, my lord. He was Defense Secretary. And then Mr. Aziz Ahmed was mentioned. He was Minister of State for Defense. He was also not examined, my lord.
इनके घर पे फोन आया था सुबह मुल्तान में आगे पढ़
My lord, the second question that your lordship, that your lord had raised was whether in the examination in chief or in the confessional statement of Masood Mahmood there was any direct direction, orders of Shaheed Zulfikar Ali Bhutto with reference to explicitly stating that Ahmed Raza Kasuri be killed, or words to this effect. My lord, from the perusal of these two statements by myself, I have not been able to come up with any direct orders or direct words which have been said by Masood Mahmood. There's one single exception, my lord, and that is that is also after the incident, and that is your lordship would find Masood Mahmood's statement or examination in chief at in volume 2, my lord, page 64, and the relevant portion is at page 75. Type page 75, my
Can you just read it?
Yes, my lord. It says, this is subsequent to the incident having taken place in Lahore. He says,
After the killing.
after the killing. my lord. Although at the meeting that I had with Mr. Bhutto after the murder, he piped down after hearing me. There were other occasions, now this is the relevant portion, my lord. There were other occasions on which he continued to goad me into getting Mr. Ahmed Raza Kasuri assassinated. So this is his own words which he is using, and there is otherwise nothing which is connected directly to Mr. Shahid Zulfikar Ali Bhutto, my lord. So since this was there, and since...
Is it not surprising when we are talking about a court of law and not someone's drawing room?
My lord.
If in a court of law someone testifies, take care of him, would not the judge ask what you mean by that?
My lord, it should be, and...
If not the prosecution or the defense?
My lord...
Maybe the defense would not want to cement the case against the accused, but certainly the prosecution should clarify. So what do you mean by taking care of someone? I mean, you may be going to court and say, take care of whatever. I mean, it may be misconstrued also.
Yes, my lord, the word take care of has more than one meaning. And
The obvious meaning is to look after someone.
Yes, my
in
lord.
a positive way.
Yes, my lord.
But it's also used in a negative way. But then should that not be asked to the witness?
My lord, I am trying to get my hands on a judgment which when I do, I will supply to your lordships, and that is of England, sometimes in the 50s, when there were two hooligans who were breaking into a biscuit warehouse, and one of them was a juvenile. He was in front and the other one was behind him, and the one behind him, when they were encircled by the constables, said to him, "Let him have it." And the boy took out a pistol and shot one of the constables. The elder hooligan was subsequently convicted for murder, and he was sentenced. But subsequently, the matter went before the Lords in appeal, and they then came to the conclusion that the word "let him have it" has more than one meaning, and therefore he was then granted a royal pardon. This is the Bentley case, my lord. I'm trying to get my hands on it. The moment I do, I will supply it to the
You can
court, my lord.
cite a case from our own jurisdiction, the Indo-Pak jurisdiction, which was previously they used to order he be hanged,
My lord.
and then someone raised the objection. It doesn't say kill. So then they started adding the word till he is dead. Previously they would not say these words, and that benefit was given for till he is dead. Okay, hang him, not take him down. So this is, I don't have the reference, but
My lord, now I would come to this, if your lordships would be good enough. I have supplied another
brief synopsis of
my lord. This is only 10 pages, and I will just very quickly read your lordships through it, because otherwise it would consume a lot of your time if I was to go into details. My lord, the first question is that of admissibility in Article 186 of the Constitution. The instant reference, the words "any question of law," appearing in Article 186, Constitution 73, are of importance, as there is a point of view that in advisory jurisdictions, matters decided in adjudicatory jurisdiction cannot be considered. The word law envisages civil law, criminal law, conventional law, customary law, divine law, elementary law, enacted law, federal law, fundamental law, and international law. that according to Black's Law Dictionary, 10th edition, at page 10015, the word law includes judicial precedent. And this I've attached, my lord,
Yes.
with paper book 1
Okay,
at
we can
tab
see that.
3, my lord. Then we go on further, my lord. That common law, according to Black's Law Dictionary, 10th edition, at page 334, is the body of law derived from judicial precedent rather than from the statutes and constitutions. In Pakistan, there is a mix of common law, Sharia, tribal, and civil law. It is a mixed system of law, and this, again, I have annexed. Further, in Black's Dictionary, 10th edition, at page...
We got the point.
My lord.
Go to the next point, we'll read it.
Right, my lord. My lord, then the word law includes what I'm trying to show to your lordships is that the word law includes precedent law. And then I have quoted from Justice Mansoor Ali Shah's judgment in PLD 2024, Supreme Court 7 at 22 at Supreme Court 7 at page 12, paragraph 5.
But
And
won't this, on the contrary, weaken your contention?
no, my lord, if
Because it says finality of decision of the Supreme Court.
Yes, my lord. What I'm trying to emphasize here is that precedent law is something which is to be followed by all courts under Article 189. And therefore, it is essential for this court to look into the question of whether the judgment of
मैंने किया लेकिन मैंने इतना पोर्शन किया फ्रंट ही वाला बाकी ठीक
And then I go on to say that, my lord, that in Article 186, the President is asking for an opinion from the Supreme Court and not a judgment. An opinion is an estimation and not like a judgment or final determination. It is like a legal opinion given by counsel to his client, and this has been fortified in the Attorney General for Ontario versus the Attorney General for Canada, 1912. Therefore, the opinion sought in the instant reference is whether the case reported at PLD 1979, Supreme Court 53, can be termed as precedent law under Article 189, Constitution 1973.
Would you like to replace the word can with should?
Should, my lord, I would. I'm grateful. My lord, then I go on to say that the premise that the adjudicatory jurisdiction of the Supreme Court cannot be subject matter of an opinion under Article 186, Constitution 1973, in the instant reference is flawed. And I say this for the reason, my lord, that the Lahore High Court and the Supreme Court were not functioning as courts under the Constitution.
Why?
My lord, I have given, I have cut that down by my lord, but in the mainstay of my arguments, I have stated that the proclamation of emergency.
Because of that?
Yes, my lord, martial law. The proclamation of emergency of 5th of July 1977 in its Article 2 clearly states that the Constitution is in abeyance. Then the Law's Continuance in Force Order 1977, which also came on the 5th of January 1977, places fetters on the functioning of the superior courts, that is the High Courts and the Supreme Court. The Law's Continuance in Force Order 1977 also takes away all fundamental rights that were guaranteed under the Constitution 1973. That would mean that Article 4 was not available, nor any of the fundamental.
As observed by some members of the bench, then there were acquitting judges also.
My lord, acquitting judges were there, but at the same time, the courts, according to the law that was prevalent at that time, was the courts were functioning under various instruments of martial law. They were not functioning under the Constitution.
They were not independent, that's what.
And they were not independent, and therefore the provisions of a fair trial were not available, as the fundamental rights had been taken away. The jurisdiction of the courts themselves had been placed under fetters by the law's continuance in force.
That would apply to all the cases during that.
That would apply, my lord, very essentially to all the cases, but essentially this case is before your lordships at this point in time, and your lordships is also looking at
If we apply the cases to all points, or we can distinguish that the prosecutor had a particular interest, or whatever you want to call it, the person in government. I mean, normal murder cases may, between two individuals, he may not have a particular interest to achieve a particular result, because otherwise you open it too wide. I think you have to narrow it down if you're going to.
My lord, as your lord has pointed out, that the prosecutor, that is General Zia, had a particular interest, and this interest is evident from the 5th of July 1977.
Then we can narrow it down.
And my lord, even if one was to look at it prior to the 5th of July, you would find that an agreement had been reached between, that would be dwelling into the political domain, but just for your lordship's consumption, that prior to the 5th of July, on the 3rd of July 1977, a agreement had been reached between the government of Shahid Zulfikar Ali Bhutto and the opposition that fresh elections would be held. And
was that signed or not?
my lord, the only thing that was left was its signing. And then on the night of the 4th and 5th of July 77, General Zia moved and imposed martial law. And one of the first...
The point which I think which has probably not been mentioned or not stressed enough was, if it was a continuation of a trial, this had gone dormant.
Yes, my lord.
Untraced, 74 incident, Justice Shafiur Rahman's report comes in, and then it re-emerges. You know, that there must be something there. And then another aspect is that the complainant joins forces with People's Party or Mr. Bhutto seeking a ticket. I mean, what do you want to say about that?
My lord,
Has he forgiven or he had erred?
my lord, coming to the first part of your...
He's scared. I mean,
My
it could
lord.
be one of three things.
My lord, coming to the first part of your observation.
Number 4, I will add to on number 4 that he realized that Mr. Bhutto was not involved in it.
Erred. Yeah.
My lord, coming to the first part of your observation, my lord, the intent becomes evident from the fact that on the 5th, an inquiry is ordered into the performance of the FSF. This is one of the first steps that General Zia takes. Then on the 24th, if I recall correctly, my lord, on the 24th of July, 3 FSF directors are arrested. Inspectors, sorry. 3 FSF inspectors are arrested. And on the 25th, they are arrested on the 24th of July. On the 25th and 26th of July, 77, their confessional statements are recorded before a magistrate.
Which
on
date?
On the 25th and 26th, my lord, of July. Again, on the 5th of July, Masood Mahmood is taken into custody. Masood Mahmood, when taken into custody on the 5th of July, is first shifted to a mess in Rawalpindi. From there, that very evening, he is shifted to Abbottabad. where he is kept in confinement. Then on the 14th of August 1977, he writes a
Where are you getting all these facts from?
my lord,
Are they part of the record?
They are part of the record, they are part of the judgment, my lord.
Okay, they are part of the judgment.
They're part of the judgment.
इसकी कोई
you-
फैक्ट
the
शीट
point-
बना दीजिए ना आप इसकी फैक्ट शीट है इसकी कोई बनाई हुई है इवेंट वाइज जो है
सर बनी हुई है
पैराग्राफ 9 of the judgment, main judgment में है.
So then, are you saying that they were not voluntary statements, they were coerced? Is that the point you're making?
Yes, I'm trying to make that point that they were given under custody of martial law.
Or duress or what?
Or duress, and that he then writes to Zia on the 14th of August. After about 3 or 4 days, he's contacted by the FIA. Then he's brought back to brought back to Islamabad, where he makes his where he makes a statement under 164. Then he writes to the magistrate asking for a pardon, and then he makes his confessional statement at Lahore. So therefore, your lordship would see that there is a steady prodding along by the marshal.
What are the names of the actual people who are stated to have pulled the trigger?
My lord, the ones who have pulled the trigger are Iftikhar, my lord, Inspector Iftikhar.
Iftikhar what? Iftikhar.
I'll just give you the name.
Was he an approver or
No.
he was co-accused?
Yes.
All.
I'll just give your lordships the three names,
Okay.
my lord. And I'll just give your lordships the three names and and then your lordships would see that there is, with due respect, there is not only this manipulation which is taking place with reference to the witnesses, but there is another manipulation which has taken place or which took place.
In all these years since 74 till 77,
my lord,
has it come on record that I wrote this to my wife, to my whatever,
my lord, all
to
of
my
this
boss,
is,
saying that I've done this, of the approvers of the confessional statements?
My lord,
the incident took place in 77.
Yes.
We're now 74, and now we're talking about 77.
My lord.
So, my conscience may be troubled and I may be telling somebody.
My lord,
or there was total blank silence then.
My lord, I would be misleading the court if I was to make a statement.
There's nothing on record.
There's nothing that I have been able to find which is on record, my lord. My lord,
because a troubled conscience should not be troubled only when the regime changes. It may be troubled. You may write
prior also.
To your friend you may write.
My lord. My lord, the names are Rana Iftikhar.
ये क्या थे? इंस्पेक्टर थे?
Inspector थे, my lord.
Rana Iftikhar. Arshad what? Arshad जी.
And Ghulam Mustafa.
ये भी इंस्पेक्टर FSF के सारे थे.
ये तीनों FSF के थे, my lord.
गुलाम मुस्तफा के बारे में बताया गया था कि उसने तो खाली असला मुहैया किया था.
नहीं सर, वो अप्रूवर है.
नहीं
ये उस ऑपरेशन में शामिल था. गुलाम मुस्तफा, सूफी गुलाम मुस्तफा इसका पूरा नाम था.
He was in charge. He was looking after. He was supervising the squad who actually pulled the trigger. It was those two gentlemen who pulled the trigger. He was supervising.
My lord. My lord, the other manipulation that took...
One more thing.
My lord.
Did it come in record that they had also committed other murders?
No, my lord.
Similar?
No.
On the behest of Mr. Bhutto?
No,
allegedly?
No.
Huh?
There was no other allegation against Mr. Bhutto of any other.
No. But when they're confessing,
no, my lord.
Comes and confesses,
They have not named Mr. Bhutto at all.
No. I think my question is slightly different.
My lord.
The person comes and confesses or says something, but these people did not confess.
No, they made 164 statements on the 25th and on the 26th.
Iftikhar and Arshad and Sufi Ghulam Mustafa.
On the 26th of July, my lord, they made statements,
confessing.
164 statements.
In that confessional statement, did they say, I had also committed the murder of so-and-so and so-and-so and so-and-so?
No, my lord.
Okay. So this is the only murder they confessed to.
My lord.
नहीं, एक तो होता है ना, you have a hitman for, let's go along with the prosecution. So that hitman would not just do one job, he probably will do other jobs.
Do other
for you
jobs
as
as
well.
well, but there was no, that was not brought on record, my lord. My lord,
ऐसा तो जिक्र आया था ना कि उन्होंने असला जो पहले मुहैया किया था वो किसी एक्टर मोहम्मद अली और एक और किसी बंदे का जिक्र आया था कि उनको मारने के लिए भी वो
so वो, if I remember correctly, वो शायद गुलाम मुस्तफा ने
कहा था
जी सर
कि हमें असला वो मुहैया किया गया
मतलब फिर उन पे फायरिंग की उन मोहम्मद अली पे या नहीं की?
वो उस पर
फायरिंग की थी?
मुहैया हुआ था सर, उसके बाद फिर साइलेंट ऑन. The other manipulation, with due respect, is that the Chief Justice or the acting Chief Justice of the appointment of the acting Chief Justice of the Lahore High Court. On the 5th of July 1977, when martial law was imposed, and I have added that to the paper book which is with your lordships, which has PLD written on it. The order is there where by way of a martial law order, the chief justices were made governors of the province, and Mushtaq Hussain, Justice Mushtaq Hussain, was made the acting chief justice of the of the Lahore High Court. Now, this appointment was also not under the Constitution. So this would tie in with my earlier submission which I had made that the courts were working under martial law instruments.
Why don't you take the other better point? That the executive is now joining hands with the judicial. Because
on page 51,
governor is an executive function.
My lord, on page 51 of the main paper book, CMA, I have said that there is a triangle of the Chief Martial Law Administrator, the Chief Justice of Pakistan, CJP, and the Acting Chief Justice of Lahore, as an acquittal would have adverse consequences for them in terms of losing their respective positions and in furtherance of an international and internal conspiracy for the region and the country.
आपने अंग्रेजी ज्यादा खूबसूरत इस्तेमाल की है जी.
My lord, the appointment of the acting Chief Justice, my lord, it would be borne in mind that there were the leaders of the Pakistan People's Party.
How long did they remain as acting governors? The duration, was it a few days or something?
No, my lord. They continued because during the course of the trial,
kitna roughly?
It would be about almost a year and a half, my lord, because during the course of the trial, it is said that Justice Mushtaq Hussain said that he should be made the permanent Chief Justice of the Lahore High Court. An amendment was made.
No, I'm talking about acting governor.
My lord, I'm coming to that. An amendment was made whereby Justice Riaz Hussain had to be elevated to the Supreme Court so that a vacancy would occur in the Lahore High Court. So an amendment was made in the order of the appointment of the acting governor through a martial law instrument, whereby he was allowed to continue despite his elevation to the Supreme Court. He was allowed to continue as acting Chief Justice, as acting governor of the province of Punjab. And your lordship would see that the judgment...
You're talking about Justice Mushtaq Hussain?
No, my lord, I'm talking about Justice Riaz Hussain, who was the acting governor of Aslam Riaz Hussain, who was the acting governor of the province of Punjab. And since that amendment was made, therefore a vacancy was created in the Lahore High Court and in the...
You've lost me.
I'm sorry, my lord.
Chief Justice Lahore High Court...
My lord, the Chief Justice of the Lahore High Court was under a martial law order. Justice Riaz Hussain, my lord. Aslam Riaz Hussain was under a martial law order made acting governor of the province of Punjab.
All chief justices.
All just chief justice, my lord. Justice Mushtaq Hussain was made acting chief justice of the Lahore High Court. Right, my lord?
Got it.
Now, it is said that Justice Mushtaq Hussain, during the course of the trial, when the matter was before the Lahore High Court, put up a demand to the chief martial law administrator that I should be confirmed as the chief justice. This is borne out by the fact that Justice Riaz Hussain was elevated to the Supreme Court. An amending martial law order was passed whereby, despite the fact that he had become a member of the Supreme Court, was on the bench of the Supreme Court, he would continue to be the acting governor of Punjab.
But this animus would be then with Aslam Riaz Hussain or not with Justice
No, my
Mushtaq
lord,
Hussain?
my lord, I'm just coming to that.
Ji.
This was done, and Justice Mushtaq Hussain was made the permanent Chief Justice of the Lahore High Court.
Okay.
And the judgment the trial court judgment that has been signed.
No, so are you saying that Justice Aslam Riaz Hussain simultaneously held the position of a Supreme Court judge as well as
Yes, my
governor of the
lord.
province?
Yes, my lord. Yes, my lord. This was done through an amendment, by an amendment. If your lordships would like, I can show that amendment to you.
No, but then why did they not just make Justice Mushtaq Hussain both positions? He could have held them. He could have been the acting
My lord, he couldn't have been the acting Chief Justice and the acting...
He could have been the Chief Justice and the acting governor. Why not?
No, my lord, because the previous martial law order provided that the Chief Justice of the High Court will become the acting governor of the province. So therefore, if he
मैं
had...
समझ गया आपकी बात
जी सर।
अगर यही बात थी तो असलम रियाज हुसैन साहब को तो ऊपर ले आए ना सुप्रीम कोर्ट
सर ऊपर ले आए
तो फिर अब मुश्ताक साहब को वो चीफ जस्टिस भी बना दें और एक्टिंग गवर्नर भी बना दें
सर फिर he would have had to leave the
खैर ये मैं समझ नहीं पा रहा हूँ एनीवेज इसकी जरूरत क्या है
ट्रायल नहीं कर सकते थे ना
ट्रायल नहीं चला सकते थे सर क्योंकि वो गवर्नर बन जाते तो then he couldn't have sat as the chief justice.
अच्छा okay that's the point.
That's the point. I'm sorry I was a little foggy in my arguments. I apologize. But that was the point that I was trying to make.
वैसे मार्शल लॉ ऑर्डिनेंस के तहत कुछ भी हो सकता था गवर्नमेंट ट्रायल भी चला सकते थे अगर वो चाहते
तो वो तो बादशाह थे जो मर्जी मार्शल लॉ में करते. The other point that I was making, my lord, was that Begum Nusrat Bhutto challenged the challenged the detention of certain leaders of the Pakistan People's Party before the Supreme Court. Justice Yaqub, who was then the Chief Justice, and I will just give your lordships the dates, on the 21st...
So if you can just tell us the point you're making.
Yeah, my lord, the point that I'm making is that Justice Yaqub was removed from the office of the Chief Justice after he admitted the petition for hearing.
Yeah, he is now, Justice Yaqub
is the Chief Justice of Pakistan. He was removed from office by, and here again a special martial law regulation was brought, and he was removed from office, and Justice Anwarul Haq was made the Chief Justice of Pakistan.
What happened to Justice Yaqub? Sent home?
Sent home, my lord. So this is the troika that I...
Are you done?
No, my lord.
We will certainly read what you've written.
My lord, just give me another 10 minutes, my lord. My lord,
बाकी साहब एक क्वेश्चन है प्लीज इसमें जो ट्रांसफर हुआ था हाई कोर्ट फ्रॉम सेशंस टू हाई कोर्ट
जी
उस ऑर्डर में इज देयर एनी स्पेसिफिक रीजन फॉर ट्रांसफर इन टर्म्स ऑफ
No, my lord, there is no, my lord.
आप ही के लिए पूछे तो कोई specific reason है within the domain of section 526 of the CRPC?
No, my lord.
As to
Malik,
why, what is the necessity to transfer the case from sessions to the High Court?
my lord, not. My lord, Malik sir. Criminal miscellaneous applications were filed before the Lahore High Court and they were
They
disposed
have
of.
not dealt with any specific reasons.
Applications were taken into consideration and it was written that for the reasons mentioned in the application, the case is hereby transferred from.
Gee, but they were.
So reasons were there.
no reason.
He did not wrote down himself, but he say the reason mentioned in the application are taken into consideration.
Yes, my lord. It was not a speaking order as such, my lord.
It's not.
Yes,
It was not a
that
speaking
is why I'm
Ji,
trying
ma'am.
to ask this question.
Ji, ma'am. It was not a speaking order. My lord, very, very quickly, I'm grateful, but very quickly, my lord. In the advisory jurisdiction, my lord, and I'm now trying to address something that my lord.
इसमें एडवाइजरी के लिए भी आपने पैराग्राफ 3 and 4 में लिखा है कि no factual inquiry is required,
जी,
nor
sir.
any
जी,
inquiries
sir.
to be
जी, sir.
made.
जी, sir.
So only these are some admitted facts on which the opinion can be rendered by
Jesus,
this.
Jesus, because I have stated that there are two that the president can seek opinion on two types of questions of law. One is a question purely of law. For example,
One is the wider meaning of law.
yes, my lord, and one is the wider meaning of law.
Got
The
it?
question is that this judgment of the High Court and Supreme Court should not be treated as precedent under Article
That-
199
that's
of
correct,
the
my lord.
Constitution.
Yes, my lord, and then I've gone on to like your
While
lordship,
you're on the question of advisory jurisdiction,
my lord,
a hypothetical question I'm asking you.
my lord.
You know, in judgments, we give short orders. Can we give short opinions in advisory jurisdiction?
That's up to the court, my lord.
Can we?
Yes.
Okay.
Then, my lord, I'll very quickly skip on. Then I've said that the court in the advisory jurisdiction can go on to Article 187. This has also been argued, and I have also dealt on that. And I have said that here no factual inquiry is as such required.
There I would not agree with you. That's a jurisdiction which is invoked in alive cases, or for want of a better phraseology, when you're dealing with a particular writ or a appeal or whatever it is, you can invoke 187, but can you tie up 187 with 186?
Yes, my lord, according to me you can, because for the simple
I
reason.
think
You need to have a jurisdiction. The court must have jurisdiction first.
if we take, Rabbani Sahib, if we take any cognizance under Article 187, then the opinion will be converted into judgment, because
No, my lord,
yes,
my lord, your
under
lordship,
Article 186,
your lordship would
we
be.
have to give the opinion, and if we pass any order under Article
Okay,
187, that would be a judgment of the court.
175, it's all the language, not of 186. देखिए लिखा ना, the Supreme Court shall have power to issue such direction, orders or decrees as may be necessary for doing complete in any case or matter pending before it.
Exactly.
Now this is not a matter or case pending before us.
It's
I
a
don't
matter
see how
which
we can
is,
use 187.
it's a matter pending before you.
No, but it's not
Reference is a matter pending before you.
Case.
The
No, no.
distinction.
There's a case or matter would be not of the genre of 186. That's an
Doing
opinion.
complete justice justice in any case or matter pending before it.
Now suppose, let's say this matter lay unattended for 10 years.
Yes, my lord.
And we leave it unattended for the next 100 years.
My lord.
It's not a matter pending. A matter pending is something which requires adjudication. I would assume. Yes, we should attend to it, but the word case and matter should be read
With the word
together.
pending, you are saying.
Yes, I don't think we can stretch it here, unless you can persuade us. I'm not of that view.
My lord, in order to do complete justice, Justice Dura Patel also in his dissenting note had said that the primary object is to do complete justice, and complete justice would only be done.
I'm troubled there also.
Complete justice.
He could have excised the review pass. He became unanimous there. So, I don't know, I mean, that option was open to him in review. He could have certainly reiterated and said, how can I sign something?
So your basic contention is that as far as case is concerned, yes, this is not a case. But as far as matter is concerned, 186 is a matter,
my lord.
which comes within the advisory reference comes within the purview of the word matter.
Yes, my lord.
Hence, we can exercise
A window could be opened, my lord.
अगर आप 2 पढ़ेंगे तो वो आप जरा negate ना कर दें.
लैंग्वेज बिल्कुल डिफरेंट है रब्बानी साहब
Any such
186
direction.
187
We are not issuing a direction and an opinion.
डायरेक्शंस डिक्री तो वो तो फिर बिल्कुल चेंज ही हो गया ना उसका जो
हम उसको जजमेंट बना रहे
वो
हैं.
तो जजमेंट बन जाएगा वो इट विल क्रॉस द बैरियर ऑफ ओपिनियन इनटू ए जजमेंट ऑफ द कोर्ट.
तो आप ये भी कह सकते हैं कि हस्बा बिल के बाद जो ओपिनियन है दैट हैज बिकम एन ऑर्डर नाउ.
Yes, my lord, but I tend to agree with what your lordship has observed.
मैं आपके लिए बता रहा हूँ कि आप ये भी कह सकते हैं
it's become binding, man.
Now there is no difference between a case and a
186 not 187.
असबाब बिल वाला ऑर्डर कितने जजेस का था?
9.
And we are 9 as well?
Ji, you're 9 as well.
we can do that.
Can one disagree with Hasba?
Yes. Then finally, I will just come to the effect on martial law. Finally, I'll just take 2 minutes on the effect of martial law.
नहीं, आपने जो मेन आपका वो था कि बायस का, अब वो इश्यूज जो बायस के उठाए गए थे और जिन पे फाइंडिंग आ गई है, उनके अलावा कौन से ऐसे इश्यूज थे जिस पे आप कहते हैं कि ये बायस था? देखिए, आपका मेन कंटेंशन जो मैंने आपके उसमें फाइल में पढ़ा, वो बेसिक आप एक मार्शल लॉ की तरफ गए थे, दूसरा आप बायस की तरफ गए थे. बायस जो ग्राउंड्स which were taken during the High Court and before the Supreme Court on bias which had been decided, वो आप अलग कर दें. आप बोलें कि इसके अलावा कौन कौन से फैक्ट्स हैं जो कि बाद में अराइज हुए हैं, which were not before the High Court or before the Supreme Court, ये फैक्ट्स आए, उनके ऊपर हमें आप ओपिनियन दें. वो कौन से फैक्ट्स थे जो शो करते हैं कि बायस था?
वो my lord, then
अगर आप हमें आप हमें जॉट डाउन करके दे देना कि ये वो इश्यूज हैं जिस पे हाई कोर्ट ने और सुप्रीम कोर्ट ने फाइंडिंग दी हैं, ये वो फैक्ट्स हैं, ये वो इश्यूज हैं जो कि इस एक्सिक्यूशन के बाद आए जिस पे हम ऑर्डर कर सकते हैं.
Speak, my lord. I'll make that list. Very briefly, my lord, that the effect of martial law on the basis of dispensation of justice and fair trial. As a consequence of the proclamation of martial law and law's continuance in force order 1977, A, the Constitution was in abeyance. B, Article 4 and fundamental rights in the Constitution were not available. C, the jurisdictions of the courts had been badly curtailed. D, there was no due process of law. As a consequence of President's order post-proclamation 1 of 1977, High Court Judges Oath of Office Order 1977, and this was not the PCO, my lord. This was an oath under martial law regulations. Judges took oath, sang the word Constitution. The word Constitution had been removed from the oath. As a consequence of these two according to me, the courts were not the High Court or the Supreme Court, which were functioning under the Constitution 73. Judges were not judges under the Constitution 1973, and they were functioning under various martial law
We got the
instruments.
point. We got the point.
Yes, and finally, my lord, that by rule of that there was a rule by law. And this, coupled with manipulation of the state apparatus by the dictator, resulted in judicial system functioning under the instruments of martial law, denying the due process of law. And finally, my lord, the bias of General Zia, I've just pointed out to your lordships on the question of the appointments. The date in Begum Nusrat Bhutto's case was 21/9/1977.
What is this date?
My lord, this is the date when Begum Nusrat Bhutto challenged the detention.
Significance?
Significance is that on the 22nd, a martial law order was issued whereby Justice Yaqub was removed from the office of the Chief Justice of Pakistan.
He admitted on 21.
This is the date he admitted that. And finally, my lord,
We are concluding today.
Yes, my lord, I'm just concluding. Just one last word that I would say, and then I will take your leave. So, my lord, at the very end, we have that the FIRs pertaining to various attacks on Ahmed. On page 8, my lord, I've spoken about the motive, and that is that various FIRs pertaining to various attacks on Ahmed Raza Kasuri from 1972 till 1974 were registered. There were about 5 or 6, my lord. That in none of the FIRs, Shaheed Zulfikar Ali Bhutto
This is
was
written
named.
here.
This is written here, my lord.
Page what?
And this is page 8, my lord. And then the at the bottom of the page, my lord, paragraph number 2.
कौन से page 8 में?
Page 8, my lord, ये जो paper book है, ये
The
जो
thicker one or the thinner one?
the thinner one, my lord.
जी.
And at the bottom, my lord, I had reached the bottom of that page, paragraph 2, that the remarks of Shaheed Zulfikar Ali Bhutto made on the floor of the National Assembly, I won't read them because we are well aware of those, and the speeches of Ahmed Raza Kasuri in the National Assembly, they were taken in as evidence. And my saying is that there was martial law, the Constitution was in abeyance, therefore Article 66 of the Constitution, which is the privilege of a member of Parliament as to his right to what is said in Parliament, and the vote cast by him would not be made will not be called in question in any proceedings.
Yep.
That was not available, and all the collaborative motive, that all the collaborative statements with reference to the motive are given in paragraphs 486, 469, 468, 469, 470, 473 of PLD 1979 Supreme Court 53.
Did the Supreme Court mention Article 66?
No, my lord, there's no mention of it at all. Because it was not in the field at that time, my lord.
What?
Article 66.
It was in the field.
No, my lord. The Constitution was in abeyance.
No, but otherwise it was in the field.
It was in the field. Otherwise, it was in the field. But
So how can you rely upon something said in the National Assembly?
Yes, that is exactly what my case is. I'm grateful, my lord,
Thank you very much.
for your patient hearing, and I've tried to be as brief as possible.
Attorney General, आपसे हमने एक सवाल पूछा था about Masood Mahmood's whereabouts. कुछ पता चला था आपको?
looking for it, your lordship, क्योंकि record सारा जो है वो digitalized नहीं है, पुराना record है. So far we have been only able to find one letter which Mahmood Masood wrote, my lord, but that was an earlier letter regarding his kids कि जी वो मैं उनको बाहर भेजना चाह रहा हूँ.
वो किधर है? Can we have that?
My lord, उसकी
जो पर ये है हमें दे दे.
my lord.
ये कॉपीज नहीं बनाई आपने?
क्योंकि अभी रिकॉर्ड हम ढूंढ रहे हैं जी वो
नहीं
सारा
नहीं, तो जो कुछ है तो दे दें, बाद में
माय लॉर्ड
आता
इसका
जाएगा।
मैं बना देता हूँ जी, इसकी कॉपीज बना देता हूँ।
ये किसको लिख रहे हैं?
माय लॉर्ड ये सेक्रेटरी फाइनेंस को लिख रहे हैं।
तारीख क्या है?
ये तो पहले का है, 25
पहले का है, माय लॉर्ड।
77 की बात है,
माय
मैं
लॉर्ड,
पोस्ट की बात कर रहा हूँ।
माय लॉर्ड पोस्ट में
ये
कोई
तो
नहीं
प्राइम
है।
मिनिस्टर को लिख रहे हैं ना,
माय लॉर्ड,
जुल्फिकार अली भुट्टो को लिख रहे हैं। हाँ, ये भी दे दीजिएगा, मगर हम व्हाट हैपेंड टू हिम?
दूसरा जो है वो
नो नो, वेयर व्हाट हैपेंड टू हिम?
मान लो अब किसी को कोई, क्योंकि हमें उनका रिकॉर्ड, क्योंकि वी ट्राइड कि एफआईए से पता लग जाए। एफआईए कहती है कि जी हमें उसके पासपोर्ट से, अनलेस वी हैव इस पासपोर्ट का नादरा को भी कहा, नादरा के पास तो अभी पुराना रिकॉर्ड नहीं।
Whenever you find it, please file it.
माय लॉर्ड वी आर
There's a missing link here.
माय लॉर्ड तीन जो है हमारी मिनिस्ट्रीज इसके ऊपर काम कर रही हैं राइट नाउ।
ठीक है,
माय लॉर्ड
आप कुछ कहना चाहते हैं मजीद, या हम रजा साहब को सुने में? क्योंकि
माय लॉर्ड अगर एजी साहब आ जाएंगे उस वक्त तक ही इज इन अ मीटिंग माय लॉर्ड राइट नाउ।
चलें, ठीक है,
वो अगर आ गए तो नहीं तो आई विल मेक।
आइए कसूरी साहब।
grateful to you.
सबसे पहले बात आपसे उन्होंने कहा, वन ऑफ द लॉयर्स अर्लियर हैड सेड कि आपने जो प्राइवेट कंप्लेंट फाइल की थी वो इट इज नॉट ऑन रिकॉर्ड। हमने आपसे कहा था कि अगर आपके पास है कॉपी फाइल कर दें। आपके पास कॉपी है उसकी, आपकी प्राइवेट कंप्लेंट की?
First, 45 years old.
नहीं है तो क्या नहीं,
I don't.
ठीक है, फाइन, ओके।
I don't have. See.
No, we not expect you to have it anyways. But you had filed a private complaint.
Yes, I filed and it was transferred to Lahore High Court because once the prima facie case was built before the Session Judge Lahore, I filed a transfer application before the Lahore High Court on the ground that since the accused are very high up and very powerful, Session Judge Lahore will not be in a position to dispense justice. So on that ground, the matter was transferred to the Lahore High Court. See.
No, but that application is not referred to anywhere. आपकी application में ट्रांसफर हुआ था?
मेरी application पर।
मेन केस या सिर्फ प्राइवेट कंप्लेंट? एक तो एफआईआर केस है, एक प्राइवेट कंप्लेंट है। एफआईआर की दरखास्त तो प्रोसिक्यूटर ने दी थी या आपने दी थी फॉर फाइलिंग फॉर ट्रांसफर?
No. It was. You see, the whole thing is that a commission was an officer of the armed forces, General Shams Kalu, was appointed as inquiry officer to look into the atrocities of the federal security force. And while he was, trying to find out...
Again, my question is, main case, FIR case was transferred on whose application? You filed...
Not my application.
State filed that application.
State.
And for private complaint, you filed your own application.
I'll explain to you. While this petition was before the Lahore High Court, we had placed the FIR with it, and my counsel was former judge of the Lahore High Court, Sheikh Shaukat Ali, and then the judge said, there's FIR. He said, yes, sir, there's FIR. What happened about that? He said the matter was closed on the ground that the accused are not traceable. The judge said, call the Attorney General. And the Attorney General called it the Advocate General. Advocate General was busy somewhere, so Assistant Advocate General Rashid Aziz Khan, who later on became the Chief Justice of Punjab High Court and later on Judge of this Honorable Court, Supreme Court, he was Assistant Advocate General. He appeared before the court, and Judge said, Mr. Rashid Aziz Khan, there's an FIR, linked up to this transfer application. What happened about it? And find out from your client, the Punjab government, what they plan to do about it. So he said, sir, give me fortnight time. And when he returned, then he made a statement that the government is bringing the police challan before the court. And then we thought that for us, to establish a private complaint is very difficult in such an important case.
When did you file it, the private complaint?
Private complaint was filed
किसी और के लिए ना वेट करें.
A private complaint was filed on the 31st July 1977.
The murder took place in 74.
After 3
why
years.
did you take? Why did you wait so long?
The case was closed.
वो तो बहुत पहले close हो गया
जब
था.
close हो गया ना जी, तो जब close हो गया, so then we filed this case when
नहीं तो आप तो उसका करते ना कि जी देखें इन्होंने नाइंसाफी की है, केस क्लोज कर दिया, प्राइवेट कंप्लेंट आपने फाइल कर दी, वो तो हमें समझ आता है. तो आपको 3 साल क्यों लगे प्राइवेट कंप्लेंट फाइल करने में? इसका क्या जवाब होगा?
इसका जवाब यही है जी कि we were feeling that the conditions are not very congenial, because Mr. Bhutto was the Prime Minister of the country. It was not congenial. They also, they were trying to hoodwink the prosecution. They were calling the prosecution.
The more reason you should have filed it, na? More reason you should have filed it, because if you are saying he would be manipulating the trial and everything, more reason you put a private complaint that the prosecution doesn't kind of give extraordinary benefit. Private control mein to then the matter in a partly comes under your control.
But you see, we were of the view that probably we will not.
When you say we
will not be comfortable in the court.
When you say we, what do you mean?
Myself, you see.
How many brothers sisters आपके हैं?
We were originally 6. 4 have gone to the other world.
And in 74, how many there were?
In 74, all the brothers were there.
Nobody else came to the light.
बाकी किसी आए गवाही देने के लिए? बस आप ही आए हो बहन भाइयों में से? बहनें भी थी, भाई थे आपके सारे?
We were only 6 brothers, no sister.
And you were the eldest or the youngest or in between?
I am from number 5.
So bade bhai didn't join you?
Bade bhai, he eventually retired as a federal secretary, and the other one was in the army. And third was also member parliament.
A well-connected family. Well-connected, powerful family.
See, my late maternal grandfather was a judge of the Awadh High Court way back in 1898.
Who?
Nawab Ishaq Khan, and Motilal Nehru used to appear before him as a counsel.
So how
and
the question arises.
And my grandfather is Nawab Muhammad Ismail Khan, who was number 2 man after Qaid-e-Azam in All India Muslim League, who appointed your father as the chief of the Muslim League in Balochistan.
He was a member of the Central Working Committee, just like my father was. No, but the question then arises is, which I hope you don't mind, but it's our duty to ask you, then you'll say, and we never asked you this question, is you were a family of considerable means, well-established connections, federal secretary, army, everywhere your family is there. How would a family like yours get so easily intimidated that it would not file a private complaint after the prosecution, as per you, wrongly closed the case? What would be a reasonable answer?
Reasonable answer is that we were waiting to see that
Where is the copy of that complaint?
कह रहे नहीं है।
वही तो नहीं है।
नहीं है।
कॉपी नहीं है जी, मेरे पास तो नहीं है। चीफ जस्टिस साहब ने कहा था कि अगर मेरे पास है, आई डोंट हैव।
और इसमें एक बात और ऐड कर दें, you did not challenge the order. Sorry साहब,
जी,
order of closure of the case that has not been challenged. वो भी साथ बता दें कि कंप्लेंट लेट क्यों और वो ऑर्डर क्यों नहीं चैलेंज किया जिसमें एफआईआर क्लोज की गई।
ऑर्डर ये जी हुई है अपना
5 तक ऑर्डर कायम है।
ये अपनी कोई 77 में क्लोज हो गई। सी ऑन द रिपोर्ट ऑफ डीएसपी वारिस, he gave made a recommendation, and then that report is signed by IG Punjab Rao Rashid and the Home Secretary, and this Rao Rashid was later on became the Secretary General of the People's Party. He wrote on the report that on the FIR that it should be consigned to the to the record room. So, sir, let me.
The other question that has come up is that afterwards did you have a rapprochement with Mr. Bhutto, that you again came into the party, you applied for the ticket? I mean, if you hold responsible for your father's murder, that would be a person who you would not want to probably meet, let alone apply for a ticket from.
Position is, sir, that I knew that I was a marked man. And even when Mr. Bhutto stepped down and PNA, they were constantly contacting me to bring the bottle in which I had preserved the blood of my father and his clothes. And since I'm a very attractive public speaker, they asked me to join us in the campaign. I knew that all those people are jokers. Bhutto will, you see, get me killed, you see, because I have got the FIR, and that's a ticking, you see, it can blast any time, you see.
Then we'll create another contradiction. If you were aware of Mr. Bhutto being such a powerfully vindictive, then why would you speak against him? In the first place. Then why would you speak against him in the first place? This man is very vindictive. I better not speak against him. So, yes. We have that problem then. What do you say to that?
The position is, let me tell you.
Ji.
I became a member of the Central Committee of People's Party at the age of 29. At the age of 31, I was elected member of the Constituent Assembly of Pakistan. At the age of 32, I was given the highest award of the People's Party, Nishan-e-People's Party, which was given only to 5 people in a convention held at a PIDC hall, Clifton, Karachi. And those 5 people whom the highest award of the People's Party was given was one Bhutto gave to himself, Nishan-e-People's Party, number 2 to Mir Subhash Talpur, number 3 to Sherpao, who was later on became the governor of Frontier, and 4th to Mehraj Khan, and 5th to myself. He didn't give this title to either to Muswa Khar or Mehraj Khalid or Hafiz Pizada. What I'm trying to show is that I was a very, very powerful person in the Peel Party. Bhutto would not move an inch without me because I was a very powerful student leader. I was very powerful student leader.
फिर ये जो बातें जो आप कह रहे हैं तो इससे तो फिर ये मोहब्बत नफरत में कैसे तब्दील
मैं बताता हूँ, मैं आ रहा हूँ ना, मैं ये कर रहा हूँ कि मैंने इसलिए नहीं रहा कि मुझे कोई चीज मिली नहीं, इसलिए मैं I revolted. No, I had everything. See, I was very most powerful person in the Peel Party. My differences started. Bhutto made 4 statements. Number 1, on the 14th of February 1974 at Peshawar, that People's Party would not be attending the forthcoming session of the National Assembly because we would be treated as double hostages and that will be going to slaughterhouse. That's his statement number 1. His number 2 statement on 28th of February 1971, the venue is Iqbal Park where he's addressing a public meeting. 28th February 1971, venue is Iqbal Park, Lahore. He is addressing a public meeting where he said, whosoever will go to Dhaka, his legs will be broken, and whosoever will be going to Dhaka, he will be going on a single fare, meaning thereby that he will not return in a single piece. His 3rd statement is 14th of March 1971. Venue is Nishtar Park, Karachi, where again he is addressing a public meeting, and there he said, you are the majority party of East Pakistan and I am the majority party of West Pakistan. Therefore, separate transfer of power in East Pakistan.
But these are political questions. How does it affect you?
मैं बता रहा हूँ मेरे differences क्यों हुए थी, मैं आपने सवाल किया उसका जवाब दे रहा हूँ.
Difference.
So and East Pakistan and the headlines in the newspaper was either tum either hum, you see. And
ये तो murder case की बात है.
जी मैं बता रहा हूँ जी,
आपने अपने बयान में ये बातें कही.
ये सारी चीजें हैं जी, they are all mentioned.
ठीक है. अच्छा.
And
ये 71 देखिए 71 में तो Mr. Bhutto is not Prime Minister. 71 की बात हो रही है, अब हम 74 में मर्डर हो रहा है, ठीक है. तो relevant time में बात करें ना.
There have been 18 attacks. They were earlier about 50.
अगर वो तो आप खुद इनको तो नहीं नॉमिनेट कर रहे हैं, आप दूसरे लोगों को नॉमिनेट कर रहे हैं उनमें. कितने आप टोटल एफआईआर आपने कितनी काटी हैं टोटल
कोई 10-12 कोई
बिफोर द इंसिडेंट
10-12 हैं बिफोर द एफआईआर हैं. एंड देन since I was member of parliament, each time I would go to parliament and get it recorded to see that I have been attacked. To see, I will take up the issue at the floor of the house. To see, so before the everything is
before the incident where your father lost his life, how many attempts were made on your life?
At least 15 or 16. In one attack, in Kasur attack,
in none of them you nominated.
In Kasur attack, I was hit with 3 bullets. 2 on my left leg.
Who did you nominate there?
That was Yaqub Man, who was MPA. I got him elected as an MPA, from Kasur. And
who was he in which party?
He was MPA. Yaqub Man, and he was promised that kill Ahmed Raza Kasuri, and we will appoint you as a minister in the Punjab government. And he was one of my lackeys, and he launched an attack on me in which I was hit with 3 bullets.
कसूरी साहब खाली इतना पूछा इन्होंने कि वो 15-16 जो पहले एफआईआर हैं उनमें आपने मिस्टर भुट्टो को नॉमिनेट किया या नहीं किया? बस
उसमें मैंने नहीं किया. When the last came, I said now enough is enough, and my father's killed. I said now enough is enough. And I thought now is the time to strike hard. So the position is, sir, that his 4th statement is, when the military action started on 25th of March 1971 in Dhaka, when he returned, the world press was there at the Karachi airport to receive him, and press and asked, what is your reaction about this military action? He said, Thank God Pakistan has been saved. He was a political leader. He should have said that today the foundation of the destruction of this country has been laid. But
Mr.
instead, he
Kasuri,
said,
let us focus on the murder case. Let us focus on the murder case. We may want to hear you on some other occasion, all your valuable insights. But this, no. Let's focus on the murder case.
अब मैं यहाँ से यहीं इसको वाइंड अप कर दूं
नहीं ये देखिए
मैं थोड़ा वाइंड अप कर सब मैं दो वर्ड में थी The position is that
you may or may not, I may or may not agree with a policy of a political leader, but the question before us is the murder case and the advisory opinion the president has sought that not to cite this as good law. That's all.
Sir, the position is that those very friendly relation turned into hostility by going to Dhaka. I was the only man. It is also part of it. I was the only man from
Learned Council, I think, let's focus on the...
मैं इस complete कर लूँ क्योंकि बड़ा important सवाल है कि मैं क्यों? I was the only man from West Pakistan who went to Dhaka on 3rd March 1971 when the session was called. You see. And this, my going to Dhaka, Bhutto thought that I have lifted banner of revolt and that I have turned traitor to the party. From there, the warmth had come to an end and cold relations started, and then he started, you see, attacking me. You see. That's the background.
जब वो नारा ये लगा था आप जो कह रहे हैं तो गवर्नमेंट में कौन था, प्रेसिडेंट कौन था, प्राइम मिनिस्टर कौन थे?
कौन सा नारा जी?
जो आपने जिसका जिक्र कर रहे हैं, अगर आप ये बात लेके भी चल रहे हैं तो फिर बताइए ना, हुकूमत तो उस वक्त अभी तक नहीं है ना जुल्फिकार अली भुट्टो की।
नहीं, गवर्नमेंट तो सो कहते मार्शल था याया खान का,
वो बर्दाश्त करेंगे अगर वो उनको पसंद नहीं है ये बात?
इसको नहीं
देखिए बात तो आप कहें कि जुल्फिकार अली भुट्टो साहब छा गए।
भुट्टो ने कहा कि नहीं, जो जाएगा ढाके मैं उसके टांगे तोड़ दूंगा, जो जाएगा यकतफा। मैं वाहिद आदमी था from the entire West Pakistan who on the call of my conscience I went to Dhaka to attend the session.
That is commendable.
अगर वो
session come to the case.
सर अगर वो सेशन हो जाता तो आज हंसता बसता पाकिस्तान एक तो घुर जाता। वो सेशन नहीं हुआ, then it's a history. आधा पाकिस्तान टूट गया, फौजें हार गईं, हजार लोग मारे गए, innocent लोग. I was the only man who went to Dhaka. That going to Dhaka was considered by Mr. Bhutto that I have turned traitor to the party. And from there onward, the differences starts. I hope I'm clear.
Have you answered anything else you want to say?
Now let's come to the facts. केस के बारे में आपने सुना, उनने points लिए हैं, आप उनके बारे में क्या कहते हैं? Was there any bias on the part of the judges then presiding over the case?
The position is that in the High Court there were 5 judges. And the bias was only on Mauli Mushtaq.
You accept?
And just a minute, sir. See, and you know, sir, that Chief Justice of a court is not the boss of the court. He's the one among the equals. When they are sitting in the bench, even the junior-most judge has got equal vote, and the Chief Justice has the equal. So there were 5 judges, and Mauli Mushtaq was not an author judge. Author judge is Sheikh Aftab Hussain. He is the author judge. He was not biased. And see, the Chief Justice...
Fine. Let's move on to the statement of a retired judge of the Supreme Court, where he made certain disclosures about the proceedings and what happened, transpired between him and some of the judges of the High Court. What do you say about the Supreme Court?
The Supreme Court, see, the position is that the Chief Justice, Sheikh Anwar al-Haq, he's the author judge.
No. There are certain TV interviews.
I'll come on that point. You see, first let me explain. Chief Justice Anwar al-Haq is the author judge, and let's presume that he was instructed by General Zia to decide in a particular way. So he sentenced, the appeal was dismissed and Bhutto was sentenced to death. So see, now he should have been, you see, one of the blue-eyed boys of General Ziaul Haq. He should have been, Sidi, because उसने जो कांटा था उसकी पहलू से वो निकाल दिया, see, and made things comfortable. तारीख क्या कि हमें बताती है? तारीख बताती है कि जब PCO came, Sheikh Anwar Haq refused to sign, you see, and he went home premature. जो शख्स PCO की ओथ लेने को तैयार नहीं है, how will वो कैसे एक इनोसेंट आदमी को फांसी लगा देगा? नंबर 2, चीफ जस्टिस कौन बना? जस्टिस हलीम, जिसे भुट्टो को बरी कर दिया. ये अजीब है कि जिसे सजा दी वो तो घर चला गया. उसी ज़ियाउल हक अजीब किस्म का बंदा है कि जिसे अपना सजा दी उसको तो घर भेज दिया, और जिसने भुट्टो को उसकी विशेस के अगेंस्ट बरी कर दिया उसको चीफ जस्टिस बना दिया. For 7-8 years he became for the longest time the chief justice of this country, and he took also oath of the PCO. So that makes very clear कि शेख अनवर हक was not instructed by anybody. सारे जजेज उसे अपने अपने ज़मीर के मुताबिक फैसला दिए थे. जिन्होंने समझा कि ये बरी ज़िम्मा है उन्होंने बरी कर दिया, जिन्होंने समझा कि ये नहीं he should be acquitted, they acquitted.
ये तो आपका एक अंदाजा है, लेकिन एक कुलीग ने टीवी पे आके सारी कौम के सामने कह रहे कि हम जजेस जो हैं वो तो जो उनके अल्फाज थे उससे आप कैसे डिनाई करेंगे?
जी वो जो है
यानी आपसे बेहतर पोजीशन में थे वो जो बाकी अपने कुलीग्स को जानते थे.
ये देखना बात ये है कि वो जनरली कह रहा है कि वो बड़े सी जैसे
आपके स्टेटमेंट को और उनके स्टेटमेंट को कंपेयर कर लो, उनके स्टेटमेंट की अहमियत ज्यादा है.
वो जो बात कह रहे हैं कि देखें साहब, उसी जजेस भी तो इंसान होते हैं, उनको भी तो डर खौफ होता है. उसी अब चीज़ ये है कि अब यहाँ जो मैं इनका बात क्लियर कर देता हूँ. उसी ये आ जाइए पेज 7 पर आ जाइए ऑफ दिस अपना ये जो उनका ट्रांसक्रिप्ट है.
आपने लगाया है
जी ट्रांसक्रिप्ट आपके पास है जी? ट्रांसक्रिप्ट थी जी,
ये उर्दू वाला
ट्रांसक्रिप्ट
रब्बानी साहब ने भी लगाया है, सबने लगाया, 2-3 लोगों ने.
मैं ज्यादा नहीं पढ़ूंगा, मैं रेलिवेंट पोर्शन पढ़ूंगा सिर्फ सी.
जस्ट वेट.
पहले ये मैं बता दूं, ये जो शख्स है इफ्तिखार, he is widely known as इफ्तिखार फितना. इफ्तिखार फितना.
Let's not go on to that. Let's talk about
all right. The position is कि ये see, I picked him up in the field party way back in 68 or 69.
Which page?
ये पेज है 7.
अब खुदा ना खास्ता उनको कुछ हो गया तो मोटिव तो आप पे हो गया.
इफ्तिखार साहब
क्या जी?
खुदा ना खास्ता इफ्तिखार साहब को कुछ हो गया.
किसको हो गया?
खुदा ना खास्ता इफ्तिखार, अगर आपकी लॉजिक फॉलो करें, खुदा ना खास्ता इफ्तिखार साहब को कुछ हो गया तो कसूरवार तो फिर आप ठहरे.
मैं कैसे ठहरा जी?
आपने जो बात कही
widely known.
नहीं तो
widely known. चलें जी इसको
जरा ये बात ना करें.
Page 7.
जी अपना पेज 7 पर आ जाइए.
we only heard it from you.
Please, page 7.
इफ्तिखार अहमद सर, ये जो भुट्टो जुल्फ़िकार अली भुट्टो का हिस्टोरिकल केस है, इसमें जनरल हसन दर्ज हुए नसीम हसन शाह. नहीं, मेरा नहीं ख्याल असरअंदाज. हमें तो किसी ने नहीं कहा. अपना उन्होंने क्लियर कर दिया. हमें तो
प्लीज पढ़ लें पहले.
हमें तो किसी ने नहीं कहा इस तरह के फैसला करो, इस तरह फैसला ना करो. हो सकता है कि चीफ जस्टिस से बात करते हों और वो थोड़ा बहुत इनडायरेक्टली हमसे कहते हों कि इस तरह कर लिया जाए तो बेहतर है. लेकिन मैं 26 साल सुपीरियर कोर्ट्स का जज रहा हूँ. मुझे एक दफ़ा भी ये याद नहीं कि किसी ने हमें कहा हो कि फैसला इस तरह से करो. और ये मेरे वेरी क्लियर कि मैं 26 साल से जज रहा हूँ सुपीरियर कोर्ट का, मुझे किसी ने नहीं कहा.
थोड़ा आगे थोड़ा और पढ़ लें.
یہ جج جو ہیں وہ خود ہی ڈر جاتے ہیں. یہ اب جنرل بات کر رہے ہیں, خود ہی ڈر جاتے ہیں کہ ہمیں پتہ نہیں زمین لی ہوئی ہے, ہمارا بیٹا ملازم ہے, ہمارا یعنی اب کنفرمیشن کا مسئلہ آ رہا ہے تو ہمیں فوجیوں کو ناراض نہیں کرنا چاہیے. دس از جنرل اسٹیٹمنٹ از میکنگ. بٹ ایز فار ایز ہی ہمسیلف کنسرن, وہ کہہ رہا ہے کہ میں نے 26 سال جو ہے I was on the seat of higher judiciary and never somebody talked to me. So how can one we rely on this statement? پھر وہ
یہ تو سپورٹ کریں گے نا.
میں تھوڑا سا پڑھ دوں گا ایک. اپنا سر پلاٹ تو آپ نے بھی لیا, غوث علی شاہ جب وزیر اعلیٰ تھے. جی اسی ساتھ پر یہ ساتھ ہی پہ اس سے آگے جہاں سے میں نے ختم کیا اس سے آگے. سر پلاٹ تو آپ نے بھی لیا, غوث علی شاہ صاحب جب وزیر اعلیٰ تھے سندھ کے, آپ ان کو ایک درخواست لکھی کہ آپ کو کراچی میں آنا جانا رہتا ہے اور کراچی میں آپ کے پاس رہائش نہیں ہے, تو اس درخواست پر غوث علی شاہ صاحب نے آپ کو ایک پلاٹ دیا جو بعد میں آپ نے فروخت کر دیا. تو پلاٹ آپ نے بھی سر لیا. نسیم حسن شاہ, غوث علی شاہ نے تو نہیں دیا میرے خیال میں, یعنی اس زمانے میں تمام جج صاحبان یا دیگر حضرات کو بھی گورنمنٹ سے پلاٹ گورنمنٹ اپلائی کرتے تھے تو انہیں پلاٹ مل جاتا تھا, کیونکہ کراچی میں ہمارا آنا جانا رہتا تھا. میں چاہتا تھا کہ وہاں ایک چھوٹا سا گھر بنا لیں تاکہ یہاں بھی ہماری رہائش کا بندوبست ہو جائے. تو اس سلسلے میں درخواست ضروری اور پلاٹ ملا. جی یہ ہے. اور آگے ایک جگہ یہ بڑا امپورٹنٹ ہے, ایک جگہ جی یہ پیج 8 ہے. جی آپ سے اگر پوچھا جائے کہ کیا یہ سر مڈل میں ہے اپنا پیج 8 پر افتخار, آپ سے اگر پوچھا جائے کہ پاکستان کی عدالتی تاریخ میں ایسی کوئی مثال ہے کہ محض مشورے کی بنیاد پر کسی کو پھانسی دی گئی, جسٹس نسیم حسن شاہ. جی ہاں, میرے خیال میں یہ مشورہ تو نہیں تھا, اس میں تو وہ تھا کہ ان کا آرڈر تھا, یعنی سبارڈینیٹس کو کہ اس کو رضا قصوری کو ختم کر دیا جائے. لہٰذا مشورے کی بات اور ہوتی ہے, آرڈر کی بات اور ہوتی ہے. یہاں وہ جو کانسپریسی وغیرہ اس کو بھی وہ کہتا ہے کہ نو, وہ تو آرڈر تھا. اٹ واز ناٹ مشورہ نہیں تھا, وہ آرڈر تھا. جی
خصوصی صاحب, یہ سی ایم اے نمبر 59 آف 2024 ایک فائل,
جی
سی ایم اے نمبر 59 آف 2024, اس میں جیو کی طرف سے یہ فائل کرا گیا ہے پورا ٹرانسکرپٹ. اس میں کلپ نمبر 4 جو ہے اس کو ذرا پڑھیں آپ, پیج نمبر 2 سے
نکال دیں ذرا.
کلپ نمبر 4, سی ایم اے نمبر 59 آف 2024. یہ جیو کے رانا جوار ڈائریکٹر نیوز جیو نیوز نے فائل کرا ہے. اس میں کلپ نمبر
وہ میرے پاس نہیں. جی
وہ افتخار صاحب کا انٹرویو ہے.
یہی جو آپ پڑھ رہے ہیں وہی ہے.
جی یہ
اس سے ڈفرینٹ ہے تھوڑا. یہ
نہیں, I think it should be the same.
اس میں آپ لاسٹ لائن سے پڑھیں, کلپ نمبر 4 جو ہے اس کی لاسٹ لائن پڑھیں.
پیج نمبر
اس میں پیجنگ نہیں ہوئی بھی ہے, کلپ نمبر 4 ہے اس میں.
پتہ نہیں
جیو گئی ہے.
یہ آپ پڑھ لیں, آپ پیج 10 پہ آ جائیں. پیج 10 پہ,
پیج 10 پر آ جاؤں.
پیج 10 پہ
اس پر تو ہے ہی کچھ.
آپ پیج 10 پہ کم ٹو دا لاسٹ.
یہ نہیں اس میں
آخری سوال.
جی آخری سوال سے مولوی مشتاق صاحب کی میں بات کر رہا ہوں مولوی مشتاق صاحب کو ذوالفقار بھٹو نے یہ کہا. اس کے بعد سے پڑھیں ذرا, نیکسٹ پیج بھی امپورٹنٹ ہے.
یہ 10 کون سا ہے جی اپنا پیج آف دی ٹرانسکرپٹ آف جسٹس ڈاکٹر نسیم حسن شاہ,
وہی
نمبر 10. یہ تو ہے افتخار, ان کے خیال کی بات نہیں کر رہا میں, سر آپ سے رائے لے رہا ہوں. یہ سوال
جی ہاں وہ میرے خیال میں مولوی صاحب کی زیادتی تھی, کیونکہ وہ بہت ہی یعنی زبردست آدمی تھے اور بھٹو کے دشمن تھے, اور ان کو چاہیے تھا کہ اس کیس میں نہ بیٹھتے تو بہتر تھا. اس کے بعد نیکسٹ پیج پہ آ جائیے آپ.
یہ پیج 8 ہے جی ہماری 8 کا لاسٹ لائن ہے.
پیج 8
کی لاسٹ لائن سے پڑھنا شروع کر لیں.
پیج 8 کی
جی لاسٹ لائن جو بھی پڑھا جج صاحب, اس نے بولڈ بھی کیا مہربانی صاحب.
مولوی مشتاق حسین کی میں بات کر رہا ہوں. مولوی صاحب کو ذوالفقار بھٹو نے یہ کہا. نسیم حسن شاہ, جی ہاں میرے خیال میں مولوی صاحب کی زیادتی تھی, کیونکہ وہ بہت ہی زبردست آدمی تھے اور بھٹو کے دشمن تھے. ان کو چاہیے تھا کہ اس پر
تو اس کے نیکسٹ پیج پہ آ جائیں, اس کے نیکسٹ پیج پہ آ جائیں.
جی
پڑھیے اب سوال. سر آپ نے ایک جگہ اپنی رائے میں کا اظہار کیا ہے.
سر آپ نے ایک جگہ اپنی رائے کا اظہار کیا. آپ نے کہا کہ بھٹو کیس کی سماعت کے دوران میری یعنی آپ کی ذاتی رائے تھی کہ بھٹو کی سزا میں کمی ہو سکتی ہے. نسیم حسن شاہ, جی افتخار, اس سلسلے میں ان کا کیس بڑا مضبوط تھا. نسیم حسن شاہ, بالکل ہاں بالکل. میں نے بھٹو کے وکیل یا سے پوچھا کیا وہ موت کی سزا میں کمی کے بارے میں دلائل دینا چاہتے ہیں, تو انہوں نے انکار کر دیا. نسیم حسن شاہ, ٹھیک. اور بھی پڑھوں سر؟ اچھا افتخار, تو صاحب جج صاحب, جب آپ کنونس تھے تو جب آپ فیصلہ دے رہے تھے تو ڈسینٹنگ نوٹ نہیں کہ آپ ان کو لکھنا چاہیے تھا کہ اس حد تک سزا دی جائے. نسیم حسن شاہ, جی ہاں ہو سکتا تھا, مگر جب ان کا وکیل ہے وہ کہتا ہے کہ مجھے سزا کی کوئی پرواہ نہیں, مجھے ایکویٹل چاہیے, تو میں سمجھتا ہوں کہ بھٹو یعنی جو وہ آگے پتہ نہیں غائب ہو گیا. بھٹو افتخار, سر آپ بھی ڈسینٹنگ تو دے سکتے تھے. نسیم دے تو سکتا تھا, مگر یعنی میرے خیال میں کچھ تھوڑی سی ہماری بھی کمزوری ہے اور کچھ اس کی یا کی بھی تھی یعنی ضد اس نے ہمیں ایک قسم کا ناراض کر دیا. افتخار احمد, اچھا یا بختار نے آپ کو ناراض کر دیا, لیکن سر آپ تو خود تسلیم کرتے ہیں کہ بھٹو کو یہ ملنا چاہیے تھا, بینیفٹ ڈاؤٹ ملنا چاہیے تھا. نسیم اچھا, جی ہاں تو اب اسی طرح چلتا جا رہا جی.
یہ جو
اب اس کا تو میں نے آپ کو جواب دے دیا ہے کہ لیٹس سے پرزیوم دیٹ ہی واز بائسڈ. So he was one among the 5 judges, one among the 5, and he was not the boss.
وہ سمجھ گئے,
he was not the boss. He had one vote.
ایک سوال بتائیے, یہ جو 2 یا 3 لوگ جنہوں نے ایکچولی ٹریگر پل کی, they were posted at لاہور اور they went to لاہور.
ان کا جی جو ہے جہاں جائے وقوع ہے,
نہیں جو ایف ایس ایف کے جو 2 ملازمین تھے وہاں ہی پوسٹڈ تھے یا گئے وہاں؟
جائے وقوع جو ہے اس سے کوئی 200 گز پر ایف ایس ایف نے کر لیا جہاں یہ دیور لیونگ سی تھی.
آن دا ٹرائل کچھ آیا, were they already posted there or were they sent from Islam Abad یا پنڈی to go there and do this act? Have you understood what I'm asking?
ہاں میں سمجھ گیا جی. یہ اصل میں میرے پاس اسلام آباد میں بھی ہوا پہلے, اس کا
نہیں ریکارڈ میں کوئی چیز آئی ہے کہ یہ جو 2 یا 3 صوفی اور باقی ارشد اور
افتخار
یہ وہیں تعینات تھے لاہور میں, ان کی پوسٹنگ تھی یا ان کو بھیجا گیا یہاں سے جاؤ یہ کر کے آؤ؟ یہ کچھ ریکارڈ پہ آئی ہے
یہ
ایسی بات؟
ریکارڈ پر اتنا ہے کہ دیور ایک وہاں ایف ایس ایف نے ایک ریسٹ ہاؤس لیا ہوا تھا جائے وقوع تقریب بھی، تو وہاں دیور لاجنگ.
یہ بات نہیں آئی. دوسرا سوال یہ آتا ہے کہ آپ جو پروسیکیوشن کا کیس ہے وہ یہ ہے کہ یہ پلاننگ اور کنسپیرسی تھی، کریکٹ؟ Now the target is you, correct?
Yeah.
This is the case of the prosecution.
That's precisely the case.
Now, either it is a case of bad planning or conspiracy that they would choose a time when there were two ladies and two people and another person in the car, as opposed to, God forbid, find you alone at some other place. I mean, ایک تو ہوتا ہے نا random, on the spur of the moment crime, you take out a gun, you shoot somebody or vice versa. Another is a planned thing. I'll see, watch him, what his movements are. And now the car is full of the two ladies at the back and two gentlemen in front, and you are the intended target. So is the planning so bad that they could not find a time when you would be alone?
Well, that is for them to decide. But the question is کہ انہوں نے یہ جو گھر تھا it was on the main road.
Let's put it this way. اگر آپ وہ سائٹ پلان دیکھیں تو they were more close to you than your late father.
Yeah.
So تھوڑا سا وہ you the intended target اور
دیکھیں یہ مثلا راؤنڈ اباؤٹ ہے.
آپ وہ دیکھ لیں جہاں پہ اسیلنٹس تھے اور آپ کی گاڑی جب آ رہی تھی سو یو ور ڈائریکٹلی آپ بالکل سامنے تھے نا.
میں بتا رہا ہوں
آپ گھر بھی تو جاتے ہوں گے نا, دفتر بھی جاتے ہوں گے, تو ایسے موقع پہ کیوں چلیں جب گاڑی میں اور لوگ بیٹھے ہوئے ہیں؟ غلط آدمی کو مار دیں, سب کو مار دیں, ٹارگیٹ تو آپ تھے نا. تو وہ انہوں نے یہ ایسا وقت چنتے کہ صرف آپ کا تو نیچرلی انہوں نے ساری آپ کی موومنٹ دیکھ لی ہوں گی نا, آپ اتنے وقت دفتر جاتے ہیں, اتنے وقت گھر آتے ہیں, تو ایسا کوئی چن لیتے جب آپ اکیلے میں ہوتے. یہ I know it's a speculative question, but it's a question which occurs to me. Since it's conspiracy.
میں ایکسپلین کرتا ہوں سر کہ یہ جو گھر ہے یہاں شادی تھی اور وہاں قوالی تھی. رات کو 12 بجے
انہوں نے دیکھا نا گاڑی میں دو خاتون خواتین بھی بیٹھی,
ان کو نہیں پتا سی تھی, ان کو کیا پتا سی تھی بیٹھی ہوئی کہ نہیں بیٹھی. ان کو تو یہ پتا کہ میرا قصور ہی اٹینڈ کر رہا ہے, یہ اپنا شادی کی سی. تو وہ جو ہے یوں جب گاڑی گئی ہے پہلا فائر آیا ہے وہ میری کار کے بیونٹ پر لگا ہے, جس سے کہ
پھر وہ اچھا ایک دوسرا سوال اٹھتا ہے, پھر وہ آ کے لوگوں نے دیکھا کس کو ہم نے مارا. اب سمجھے نا, منہ پہ رومال باندھ لیتے اور آ کے دیکھتے ہمیں رپورٹ دینا. اب سنیے نا قصوری صاحب ایک سنیے نا, اب دیکھیں ایک کام دیا گیا ہے نا کہ یہ کرنا ہے. اب ہم مفروضوں میں جا رہے ہیں تو گولی ایک لگی ہے صرف, سب کو صرف ایک گولی. ایک تو ہوتا ہے نا چھنی کر دی گاڑی, وہ تو الگ بات ہے,
چھنی کی ہوئی تھی نا گاڑی,
مگر گاڑی کے اندر صرف ایک شخص کو لگی, آپ کے والد صاحب کو سر میں ایک گولی.
میری گاڑی کا جو سیٹ کا گٹ اس کے اندر 4-5 گولیاں لوج تھی, اگر تھوڑی سی اوپر ہوتی تو مجھے بھی لگتی تھی.
نہیں وہ ویریفائی کرنے آتے نا, آپ کے پاس تو کوئی اسلحہ نہیں تھا کہ آپ جوابی فائر کر دیتے ان پہ, تو آ کے ویریفائی کرتے.
میری زندگی میں نے آج تک اسلحہ کبھی کیری نہیں کیا, اور نہ میں کوئی کارڈ لے کے چلتا ہوں. میں اللہ کے پر بھروسہ کرنے والا بندہ ہوں.
سوال تو سن لیجیے نا, رات کا وقت ہے, وہ آ کے ویریفائی, بھائی باس کو جا کے رپورٹ دینا ہے نا کہ ہم نے کر دیا آپ کا کام, تو وہ جا کے دیکھیں گے نہیں ہاں کام ہو گیا ہے نہیں, اور اگر خدا نہ خواستہ مس کر دیا ہوتا تو پھر کام پورا کر کے رپورٹ دیتے نا. مجھے ذرا سا ہیومن نیچر ایک ہوتی ہے نا چیز, کہ کسی کو کوئی کام دے گا یار اس کو ختم کرنا ہے, تو وہ جا کے دیکھے گا, نہیں تو وہ خود ہی اس کو کہے گا تم کیسے نالائق آدمی ہو, کیسا تم نے کام کیا, ہاں بھائی ہاں میں نے کر دیا. تو یہ مجھے ذرا سا عجیب ہے, کیونکہ رات کا وقت کوئی ہے نہیں, کوئی ڈر نہیں ان کو پکڑے جانے کا. آپ یو آر ناٹ آرمڈ, سو دے وانٹ ٹو کنفرم کہ بھائی ہم نے کام بھی کر دیا یا نہیں. یہ مجھے ذرا سا عجیب سا لگ رہا ہے کنسپریسی, یا تو بہت نالائق,
بات یہ ہے
بہت نالائق لوگ.
اس میں اسٹیٹمنٹ میں آتا ہے کہ اس نے اسی جو تھا مسعود محمود کو جب خبر ملی تو اس نے بڑا سنپ کیا کہ تم نے کیا ایسی جو ٹارگٹ تو تم نے مس کر دیا.
یہی تو میں پوچھ رہا ہوں.
تو جی اصل میں بات یہ ہے جی کہ یہ جو تھی لائٹس انہوں نے آف کی تھی, اسٹریٹ لائٹس تھی, انہوں نے پلان کیا ہوتا, اور ये जो राउंड अबाउट है जो आपने के देखना वहाँ हैज थी, वो हैज के पीछे खड़े हुए थे।
यकीनन और लोग भी जा रहे होंगे ना, गलत गाड़ी पे ना।
रात को 11:15 बजे का रात का टाइम है जी, दिन का टाइम थोड़ी होती थी रात।
ये जगह आपके घर से कितनी दूर थी
जी?
ये जगह आपके घर से कितनी दूर है?
मेरे घर से 3-4-5 मील दूर। वी लिव इन मॉडल टाउन, और ये थी शाहजमाल राउंड अबाउट।
ओके
नहीं देखिए, जहां अगर उन्होंने प्लान किया था कि वो उधर आपको अटैक करेंगे तो वहां से आपको फॉलो किया होगा जब आप उस घर से निकले शादी वाले, और उनको ये भी पता होगा कि आप कौन से साइड पे घुसे। तो ऐसे ब्लाइंडली उन्होंने फायर नहीं कर दिया।
मेरा टेलीफोन
उनको ये भी पता था कि कितने लोग गाड़ी में सवार हैं।
मेरा टेलीफोन रेगुलरली टेप होता था, वो ये बीच में आ गया हुआ है, जब टेप होता था एंड टेपिंग से उन्होंने देख लिया कि मैंने एक फंक्शन अटेंड करने जाना है सो दे प्लान और उसमें जो था वो जो तीन जगहों पर बैठे हुए थे, एक स्ट्रेट, एक दरमियान में और एक पीछे और फॉर्चुनेटली जो पहला जो बस लगा है वो मेरा ब्योनर पर लगा, उससे मेरी पीछे की लाइटें जो थी ना ऑफ हो गई, क्योंकि वो जो मेरी तारें थी वो डैमेज हो गई, और उसको भी अल्लाह ताला का करम था, पर जो पीछे फायर करते रहे तो अंधेरा था, से दे कुडंट फाइंड आउट माय कार थी, तो उनको जो लगी है वो यहाँ से लगी है।
How old was your father when he was killed?
72.
And how old were you then?
I was about 36.
Your mother and your aunt were at the back.
At the back थी। अब चीज ये है वो ये जब गाड़ी जो है ऐसे ऐसे जा रही है, उसमें मैंने 180 डिग्री क्रॉस करके सीधा आगे जाना है अपना शाहजमाल की तरफ, तो ये पहला जो फायर हुआ है वो नहीं लगा वो गाड़ी को लगा, और जब फायर हुआ तो मेरे वालिद को तो पहली दफ़ा ये सारा था, तो उनके मेरी अभी तक मेरे रिकॉर्डेड उनकी वॉइस, उनके 2 दफ़ा उनकी आवाज़ निकली, या अल्लाह खैर, या अल्लाह खैर। सो आई न्यू कि मेरे पता अटैक होते रहते थे, तो मैंने अपना हेड नीचे सिर कर लिया और मैं गाड़ी चलाता रहा, क्योंकि अगर मैं गाड़ी रोकता हूँ तो आई वुड हैव बीन किल्ड लाइक अ सिटिंग डक तो फिर जब यहाँ आया हूँ तो ये फायर जो है वो निकला है मेरी वालदा की जिधर बैठी हुई थी मेरे पीछे, उसकी खिड़की से, और खिड़की से एंगल बन के ना।
ये तो कोई दो राय नहीं है ना, कत्ल तो हुआ है। अब एक और सवाल उठता है जो मुझे एक सवाल का जवाब नहीं मिल पाया। वो कह रहे थे कि आपसे उनकी दोस्ती थी, अप्रूवर की,
किसकी?
वो कसूर के, वो भी कसूर के थे,
अपना मसूद महमूद
जी। देखिए उनका स्टेटमेंट है कि आपके वो दोस्त थे, कसूर दोनों
करने के उनके वालिद की मेरे वालिद से दोस्ती, मेरा वालिद तो बड़ा
नहीं। अभी हम सवाल पे आ रहे हैं।
हाँ।
तो जब ये कैसा दोस्त था जिसने आपको बताया नहीं कि भाई आप पे हमला होने वाला है, ख्याल करना?
वो तो
दोस्त था ना, वो कह रहा है, या तो आप उसको जिरा करते कि तुम मेरे दोस्त कब हो, तुम झूठ बोल रहे हो, झूठ दोस्त नहीं हो। नेचुरल, देखिए एक चीज होती है ना, नेचुरल, जजेस सी द नेचुरल कॉज ऑफ थिंग्स। If somebody tells me I'm going to kill somebody or my friend, so I will inform him if nothing else.
मैं बताता हूँ जी, मेरे बाप का, मेरे वालिद जो थे, he was the only person in the undivided Punjab.
Why did he not tell you, this friend of yours?
मैं खत्म कर लूँ जी।
नहीं, आप देखें, आप कहीं और जाएंगे।
My father was the only man in the entire undivided Punjab who had a section 30 powers as an honorary magistrate. कि आप उसी शहर के रईस आज़म भी हैं और वहीं आपको 7 साल देने के इख्तियारात भी हैं। हमारी हवेली में कोर्ट रूम, अपना जजेस का, हमारे गांव के अंदर सब जेल बनी हुई सारी। तो मेरा फादर जो थे वो तो ही हैड एजुकेशन अब्रॉड इन इंग्लैंड, स्कूलिंग भी वहीं की होती, तो वो तो किसी लोकल लोगों से मिलते ही नहीं थे, बिकॉज ही वाज अ जज।
मसूद महमूद साहब कह रहे हैं वो आपके दोस्त थे।
कौन?
मसूद महमूद।
मेरे के दोस्त कैसे हो सकता है जी?
आपने बयान में गलत बात की उन्होंने।
गलत बात मेरा कैसे हो सकता है?
नहीं तो आपने जिरा नहीं की उस पर।
बात यह कि मैं तो आई एम ए पॉलिटिशियन और मेरा तो वो ही वॉज अ पुलिस ऑफिसर, और वो जब पुलिस डीजी।
देखिए फिर अगर ये बात हो ना, फिर उसकी वेरासिटी को अटैक होता है। अगर तो वो आप कह रहे हो झूठ बोल रहा है,
But it doesn't matter whatever he says, it doesn't matter.
Does matter.
क्योंकि
It matters very much.
क्योंकि I do not know, see, what prevailed with the special prosecutor, see, कि उसने क्यों नहीं सवाल किया, लेकिन हमारा कोई ताल्लुक नहीं था. See, they are sheikhs from Qasur, and
आप नहीं जानते,
we
उनको जानते ही नहीं थे.
We have been the rulers of Qasur for over 200 years. During Qasur के जितने दर दीवार सब मेरे बुजुर्गों के नाम पर हैं.
मसूद महमूद साहब को आप जानते थे as a
never knew him.
उन्होंने अपने तौर पे बना दी.
Never knew him.
चलें जी, एनीथिंग एल्स? मैंने आपका ये सारा नोट पढ़ लिया जब आप बात कर रहे थे. I've read all of it.
अच्छा, अब चीज ये है जी कि ये जो मैंने आपको किताब एक दी है,
मैं देख रहा था उसको.
जी, तो ये मैं थोड़ा बता दूं, because they said I was a non-entity. And
no. You were an entity.
No, but that's the point of view, non-entity.
नहीं, ये हमने नहीं सुनी बात. और अगर सुनी हम कान से निकाल दी.
तो ये किताब में जो तस्वीरें हैं, इसमें एक
कसूरी साहब आपकी किताब पे कसूरी साहब आपकी किताब के हवाले से एक सवाल है. ये जो एफआईआर दर्ज हुई, ये आपकी मर्जी से हुई?
मैंने की करी,
आपके रिटन एप्लीकेशन पे हुई?
मेरी फर्ज बयान आपके यहाँ फ्रंटियर में उसको मुरासला कहते हैं, हमारे यहाँ फर्ज बयान पंजाब में कहते हैं.
फर्ज बयान आपके तरफ से हुई और बड़ी मुश्किल से हुई, तो आपने लिखा है बड़ी तगोदो के बाद.
जी, बड़ी तगोदो के बाद.
उसमें आपने भुट्टो का जिक्र नहीं किया
जी?
उसमें आपने भुट्टो के जिक्र नहीं
मैंने किया कि याद रहे.
नहीं, एफआईआर में जो फर्द बयान आपने दर्ज की वही एफआईआर में आई, उसमें भुट्टो का जिक्र नहीं है?
नहीं, भुट्टो का जिक्र है जी,
ये मेरे सामने आप बताओ.
नहीं
है, आपने नहीं लगाया,
एंड पर है.
लेकिन आपने एलिज नहीं किया कि भुट्टो ने मरवाया है. याद
मैंने बताया कि ये मेरी पॉलिटिकल बैकग्राउंड है, मैं अपोज करता हूँ, और याद रहे कि भुट्टो ने उसी अपना असेंबली में कहा कि ये मेरे लिए ही इज एन एब्सोल्यूट पॉइजन एंड वी कैन नॉट टॉलरेट. उसका जिक्र किया मैंने. इसका
बस जिक्र ही किया, ये भी एलिज नहीं किया कि उसने मुझे मरवाया है, ये भी एलिज नहीं किया. लेकिन चलिए छोड़ी बात.
एक्चुअली दैट इन्फ्लुएंस क्या है, इन्फ्लुएंस क्या है कि मुझे मेरे पर अटैक होते रहे, और ये भुट्टो के साथ मेरा ये ताल्लुक है.
अब पेज नंबर 30
ये सर, इसमें मैंने तस्वीरें देखी है, जरूर देखी है. इसमें किताब के अंदर एक आपके वालिद की भी तस्वीर है. ये एट पेज 466.
कसूरी साहब किताब,
इसमें ये मेरे नाना के घर पर ऑल इंडिया मुस्लिम लीग का इजलास हो रहा है, और इसमें फ्रंट में खड़े हुए हैं अपना ख्वाजा नाज़मुद्दीन, नवाबजादा नियाकत अली खान, बेगम मोहम्मद अली जौहर, मेरे नाना नवाब मोहम्मद इस्माइल खान. ये उनके नवाब इस्माइल खान के घर पर मीटिंग हो रही. कायद आज़म अपना राजा साहब महमूदाबाद, सर छतारी, अहमद सईद खान छतारी, एंड काजी ईसा.
नहीं, वो तो हुसैन इमाम है
जी,
हुसैन इमाम है.
नहीं, आपके वाले बैठ खड़े हुए थे.
नहीं, वो तो आखिर में उनसे पहले
एंड पर. नहीं, ये वो इमाम नहीं है, ये है नवाब अहमद सईद खान छतारी. ही वाज द फर्स्ट गवर्नर ऑफ यूपी इन इंडिया, फर्स्ट मुस्लिम.
कसूरी साहब आप अपने कसूरी साहब जरा तवज्जो देंगे इस तरफ. आप अपने बुक के सफा नंबर 309 पे आ जाए. आपकी किताब के सफा नंबर 309.
जल्दी पढ़ दीजिए.
ये मतलब पढ़ती है, जल्दी पढ़ ली.
आपके पुलिस वालों से कन्वर्सेशन हो रही है
जी.
आप कह रहे हैं कि मैंने नामजद पर्चा सिर्फ और सिर्फ जुल्फिकार अली भुट्टो, गुलशाह नवाज भुट्टो, सकना लारकाना के खिलाफ दर्ज करवा रहा हूँ. आप पर्चा दर्ज कर सकते हैं तो कीजिए, नहीं तो मैं हाई कोर्ट जाऊंगा.
हाँ, ये मैंने कहा. ये जब SHO आया,
लेकिन आपने जो फर्द बयान खुद लिखा, अपने हमसाये के जरिए लिखवाया आपने.
हाँ, हमसाये के जरिए.
उस हमसाये को आपने ये नहीं बताया कि मुझे भुट्टो ने कत्ल किया. आपने कहा चूंकि मैं तकरीर कर रहा हूँ. इतनी सी बात.
देखिए, बात ये है कि these things will open up in the investigation, but मैंने मोटिव रख दिया कि इस क्राइम का मोटिव क्या हो सकता है, एंड उसमें मैं भुट्टो का जिक्र किया. जब मैंने भुट्टो का नाम दिया تو وہ جو ایسے تھا اس کے ہاتھ سے ایسے قلم کی جی جناب ایسے گر گئی تھی. تو پھر میں نے رپیٹ کیا, پھر میں نے کہا دیکھو میں نہ فارسی میں بول رہا ہوں نہ فرینچ میں بول رہا ہوں, سمپل بول. تو پھر وہ گیا چلا اپنا, تو پھر ایس ایس پی اینڈ ڈی آئی جی دونوں آ گئے.
تو آپ کا ہمسایہ جس نے فرد بیان لکھا تھا وہ پیش ہوا گواہی میں؟
جی
جو ہمسایہ تھا جس نے آپ کا فرد بیان لکھا وہ گواہی میں پیش ہوا تھا؟
نہیں, وہی بھی انٹرفیئر تھی. تو پھر چیز یہ ہے جی کہ یہ کوئی ایسے پرائم منسٹر کا نام دینا کوئی مذاق نہیں ہے. ابھی دیکھیں نا عمران خان چہرہ چیختا رہ گیا کہ میری ایف آئی آر نہیں لیتا, حالانکہ ان کی پنجاب کی گورنمنٹ تھی اینڈ بھٹو واز سٹنگ پرائم منسٹر آف دی کنٹری, اور میں نے ان کا نام دلوایا. اور مجھے یاد ہے کہ جب بھٹو نے 4 دن ایڈریس کیا سپریم کورٹ کو, اور سپریم کورٹ نے ٹائم بھی کمیوٹ کیا, اس کا ٹائم واز 12 hours. 12 hours he addressed the Supreme Court. At the end he said کہ I'm more than satisfied. تو اس میں جب اس نے یہ کہنا شروع کیا کہ یہ سیاسی کیس ہے, یہ انٹرنیشنل کیس ہے, یہ فلاں کیس ہے, تو مسٹر جسٹس انوار الحق نے he protruded his neck on the desk and he said Mr. Bhutto tell us کہ we have rightly understood. So we have understood from your argument.
اپنی کتاب جو ہے اس میں صفحہ نمبر 333,
میں ذرا اس کو ختم کر لوں, جب وہ سلسلہ ٹوٹ جاتا ہے سارا اسی. تو اس میں اس نے اپنا چیف جسٹس نے کہا کہ ہیو یو انڈرسٹوڈ یور اسٹیٹمنٹ, کہ آپ جب احمد رضا قصوری پرچہ لکھوا رہا تھا تو اس وقت جو ہے ضیاء الحق انکوگنیٹو شلوار قمیض میں آیا اور اس نے کان میں وسپر کیا کہ مسٹر قصوری بھٹو کا نام دے دو, اسی میں 3 سال کے بعد آ رہا ہوں. اینڈ کورٹ میں ایک ہنسی پڑ گئی سی تھی. انہوں نے کہا what are you saying? You were physically the prime minister of the country when the case was registered against you. See, there's no such thing کہ یہ گورنمنٹ کا ہے, یہ فلاں کا ہے. You were physically the prime minister of the country. See, اور وہ پرچہ بھی میں بتاتا ہوں میں نے کیسے کرایا. سی میں نے جب میرے اپنا نیورو سرجن نے آ کے مجھے کہا کہ قصوری صاحب دی نواب صاحب ہیز پاسڈ اوے,
ہوئے آپ کے پاس آئے
تو ڈی آئی جی ایس ایس پی دونوں بیٹھے ہوتے, وہاں ایک ڈنڈا پڑا ہوا تھا. I got hold of that stick and I gave 2-3 shots on the bottom of the SSP Halaku Khan. I said get lost you murderer, get lost. اور وہ جو بھاگا اس کے بعد ڈی آئی جی نے دیکھا کہ ایس ایس پی کی پٹائی ہو گئی, تو ڈی آئی جی بھاگا. I like a South American footballer, I gave him a kick on his ass and he went rolling. And then
Mr. Bakasuri, when you say these things, when you say all these things, on the one hand you say you are concerned, you worried by the wrath that you may face, and on the other hand you show all these acts of yours. So there seems to be a contradiction then. Either a person rightly so can be apprehensive that you is taking on the prime minister of a country, then all your other acts you say which don't seem to assist or coordinate with what you are saying. That's the problem. I can appreciate, you can say, oh, he was a powerful man, what could I do? But all these other things then you add and then you sort of undermine that very aspect of the case. Because you waited for 3 years for your private complaint. That's the problem. ہم دونوں طرف کیسے جائیں, یہ مسئلہ ہو جاتا ہے. میں سمجھ گیا ہوں, مگر آپ ہماری بھی دشواری سمجھے نا.
دیکھنے آپ کی دشواری میں ریزالو کر دیتا ہوں کہ he was sitting as the prime minister کو میری کس سے سننی تھی جی.
اگر آپ پولیس والوں کو ڈانٹ رہے ہیں, ان کو ڈنڈے مار رہے ہیں,
سر آج
خبر پہنچے گی نا اوپر.
وہ تو پرانے زمانے کی بات ہے. آج کے زمانے میں کوئی کسی کو سمبل نہیں دیتا, کسی کو کچھ نہیں دیتا, کوئی سب کچھ ہو رہا ہے.
دیکھیں یہ سیاسی بات نہ کریں. اب اس بات کو چھوڑیے, آپ بتائیے کہ چلیے بھٹو جب چلا گئے اس کے بعد آگے ضیاء الحق صاحب آگے, آپ کا کیس چلا گیا وہاں پہ ہائی کورٹ میں, آپ کی درخواست پہ چلا گیا نا.
جی
وہاں پرائیویٹ کمپلینٹ بھی پڑی تھی.
جی
آپ کی پرائیویٹ کمپلینٹ پڑی تھی, تو نولائی کیس کے تحت پہلے پرائیویٹ کمپلینٹ کو چلنا چاہیے تھا, آپ کو پتا ہے 66 سپریم کورٹ کے تحت. تو وائی ناٹ, جب ایک کیس کو آپ نیچے سے اٹھا کے اوپر لے کے جا رہے ہیں اور ایک دوسرا کیس وہیں پڑا ہوا تھا, اس کو اس کے ساتھ کیوں نہیں ساتھ جوڑا اور اس پہ کارروائی کیوں نہیں شروع کی؟
اس کا بھی جواب دیا انہوں نے جی, کہ انہوں نے کہا کہ اگر different جو نور اللہ کیس کا ذکر جو آپ کا ذہن میں ہے نا اس کا تو جواب دیا کہ since the accused are same and اپنا prosecution story was also identical, so therefore we did not think it proper to open up the complaint case separate first and the police case later on.
یہ جواب ہے کہ ایک سیٹل پرنسپل کے خلاف ایک بات لکھ دی، اسی لیے تو کہہ رہے ہیں کہ اس ججمنٹ کو پریسیڈنٹ کے طور پہ نہ دیکھا جائے. بار بار یہی تو پوچھا جا رہا ہے کہ کیوں دیکھا جائے کہ پہلے والے لا کو سامنے رکھے ہوئے اس کو ویسے ڈسٹنگوش کر دیا.
یہ دیکھیں نا جی
دوسری نہیں وہ دیکھ لیا پڑھ لیا ہم نے، بالکل وہ بالکل غلط ہے. آپ سمجھتے ہیں کہ 66 سپریم کورٹ کے تحت نولائی کے کیس کے تحت پہلے کمپلینٹ کو چلنا چاہیے تھا. دوسری بات چلیے اب اگلی بات بتا دیجیے 374
جی
374 کے بارے میں بتائیے. جب 526 کے تحت یہ کیس ٹرانسفر ہو گیا ٹو دا ہائی کورٹ، Now High Court become a session court. اس نے وہ پروسیجر اڈاپٹ کرنا ہے جو سیشن کورٹ کے پاس تھا. اب سیشن کورٹ کے پاس 374 کی ایک پروسیجر تھا کہ وہ اس کا ایک ریفرنس بنا کے وہ بھیجتا. اس کیس میں ریفرنس نہیں ہے.
اس میں ریفرنس کہاں جانا تھا؟
جہاں بھی جانا تھا اس میں نہیں ہے.
سیدھی وہ
دیکھیے سن لیجیے میری بات سن لیں. آپ کے مقصد یہ ہے کہ ہائی کورٹ سن لی تھی اسے ریفرنس کی ضرورت نہیں ہے تو سی آر پی سی کو بند کر دیں. بات 374 کا مطلب یہ ہے کہ جب تک کوئی ریفرنس افرمیٹو میں نہیں آئے گا اس وقت تک ایگزیکیوشن نہیں ہو سکتی. یہ ورڈنگ وہاں لکھی ہوئی ہے. اگر اس کیس میں کوئی ریفرنس تھا ہی نہیں اور نہ ہی کوئی ریفرنس کو افرم کیا گیا تو سزائے موت کیسے ہوگی، ایگزیکیوشن کیسے ہوگی؟ اس کا جواب
It's a very relevant question and I answer.
دوسری بینچ کو بھیج دیتے.
I answer. See, the position is that particular provision is as by way of abundant precaution that since it's a question of life and death, the matter should go to High Court for confirmation. You see, in this case, High Court itself, decided the case. And وہ جو کہتے ہیں ہمیں اپیل کا چانس نہیں گیا اور اپیل گئی 185(2) کے تحت. You see, direct appeal, not leave to appeal. You see, so the position remains the same. You see, when the High Court فیصلہ کرے گا, High Court کا ریفرنس کہاں جائے گا جہاں چیف جسٹس بیٹھا ہوا ہے. You see, and high powered bench ہے, larger bench, not a
دیکھیں اگر یہ آپ کی بات صحیح ہوتی تو جن لوگوں نے قانون بنایا تھا 1898 میں اس میں ایک شک ڈال دیتے where the murder trial has been conducted. We're only now talking about murder trials. And reference اسی میں آتا ہے صرف conviction of death میں. Then there will be no need, when the High Court itself has conducted the murder trial, then there will be no need for confirmation. یہ جملہ لکھ دیتے اس میں بات ختم ہو جاتی. آپ تو اسپیکولیشن پہ جا رہے ہیں نا.
And the word shall has been used.
تو شہر کا مطلب ہے کہ جنہوں نے قانون بنایا انہوں نے کبھی نہیں سوچا کہ ہائی کورٹ مرڈر کیسز بھی چلائے گی. دیکھیں دوسری بات یہ ہے کہ منظور ملک صاحب نے فرمایا کہ ہندوستان میں تو آج تک یہ ہوا ہی نہیں ہے.
لیکن ہندوستان میں پرائم منسٹر نہیں نا تھا جی.
اب آپ سن تو لینا پہلے تو دیکھیے نا ہم قانون بنا رہے نا, ہم اوپینین دے رہے نا. کل کو اگر دوسرے مرڈر کیسز چلنے لگے, کیونکہ ایک بات جو سمجھ آتی ہے کہ رائٹ آف ایک اپیل چلی گئی, چلے وہ تو چھوڑے. دوسری بات یہ سمجھ آتی ہے کہ کنفرمیشن نہیں ہوا, وہ بھی ایک رائٹ ہے. اٹ شوڈ ناٹ بی ٹیکن سو لائٹلی بیکاز وین یو آر کنفرمنگ the High Court can ask for additional evidence to be taken. That's also a right. So it's not simply just take rubber stamp kar diya. So it could have gone to another bench. That's one possibility. Or it was never envisaged to begin with in the law of 1898 that a murder trial and a death sentence will ever be passed directly by the High Court. So this was an extraordinary element which no other case I'm aware of in Pakistan's history has happened this way. So then that right goes away. What happens to that right?
پھر سیشن
And without a conviction, confirmation.
سیشن جج سے ہائی کورٹ جاتا ہے اور لارجر بینچ کے پاس جاتا ہے. تو
ایک جج کے پاس چلا لیتے ہیں.
ہاں, کس نے اپلیکیشن دی تھی فار کانسٹیٹیوشن آف دا لارجر بینچ؟
His position is my case was already transferred, my private complaint was already transferred in the High Court. And when the police challan came, naturally it would have looked very odd کہ پولیس چلان جائے سیشن جج کے پاس اور دوسرا جو ہے پرائیویٹ کمپلینٹ ہائی کورٹ میں. سو اٹ واز ٹرانسفر ٹو ہائی کورٹ اینڈ ہائی کورٹ میں وہ کلب ہو گئے اور کلب ہو گئے اور اس پر انہوں نے فیصلہ کر دیا. اور وہ نور الہی کیس کا جس میں اپنا سردار صاحب نے سوال کیا ہے اس کا بھی سپریم کورٹ نے اپنا جواب دے دیا. اینڈ ویری ایبل جج لائک شیخ انوار الحق, ہی واز اے فارمر ICS آفیسر, ہی واز ویری کمپٹنٹ پرسن تھی, تو اس کا بھی اس کا جواب دے دیا. اب چیز یہ ہے کہ جو جہاں تک تعلق ہے یہ ریفرنس کا, وہ اس وقت جو لا میکرز نے یہ سوچا کہ لائف اینڈ ڈیتھ از اے ویری امپورٹنٹ فیکٹر, اس کی صرف سیشن جج کے فیصلے پر اس کو نہ دیجیے unless it is confirmed by the high court. بٹ یہاں تو ہائی کورٹ اس پہلی دفعہ سن رہا ہے. اب آپ کا یہ کہنا کہ جی اس سے پہلے کوئی کیس نہیں آیا, اس سے پہلے کسی پرائم منسٹر کا نام بھی تو کسی کیس میں نہیں آیا. اٹس the first time in the history of the subcontinent a prime minister was being tried by the court.
آپ کا کہنے کا مطلب ہے کہ یہ قانون عام لوگوں کے لیے اور ہے اور پرائم منسٹر کے لیے
عام کی خاص نہیں بات ہی. This was my fear.
آپ کے جذبات اپنی جگہ پہ ہیں, قانون سب کے ایک ہے, یہ نہیں ہے کہ پرائم منسٹر کے وقت ضابطے کو چینج کر دیا جائے.
چیز جو آپ کہہ رہے ہیں اللہ کرے ہو جائے, لیکن وہی تو نظر نہیں آتا. یہاں روز جو فیصلے ہوتے ہیں اس میں بھی یہ جو آپ کہہ رہے ہیں وہ باتیں نہیں ہوتی ہیں.
اچھا اب دیکھیے 375 بھی ہے سیکشن, کہتا ہے if when such proceedings are submitted the High Court thinks that a further inquiry should be made or additional evidence taken upon any point bearing upon the guilt or innocence of the convicted person, it may make such inquiry or take such evidence itself. So it's not just a rubber stamp کہ ایک procedural requirement ہے, چلو ٹھپا لگ گیا, confirmation ہو گیا. تو یہ 375 میں سوچنے والی بات ہے.
سر provided
کیس کیسا ہو,
provided the case
نہیں اب آپ سے اس کیس کو چھوڑ دیجئے. Can I ask you as a senior counsel, forget this case for the time being. Forget this, because bad precedent, maybe you think the judgment is correct. Let's talk about precedent. So what happens to confirmation? Forget your case. I'm asking you as a senior counsel, as an officer of the court. The confirmation is not necessary when trial takes place by the High Court. Is that your answer?
My argument is that the lawmakers made this provision by way of abundant precaution that session court is a lower court and they should not, on their decision, a man should not be hanged unless it is a reference is confirmed by the high court and by the divisional bench. You see, now yahan divisional bench nahi suni, yahan 5 judges sun rahe hain, larger bench.
کیوں پانچ
دو اپرچونٹیز سے ڈپرائیو کر دیا گیا, دو اپرچونٹیز سے ڈپرائیو کر دیا گیا, ایک تو اپیل اور دوسرا یہ جو ریفرنس جو تھا, دو اپرچونٹی سے ڈپرائیو کر دیا گیا. اور 5 ممبرز بینچ بنانے کا کوئی جواز تھا؟ 2 ممبرز بینچ بھی بنایا جا سکتا تھا, 3 ممبرز بینچ بنایا, 5 ممبرز بینچ کا کیا جواز؟
Again, as a abundant precaution, that since the matter was in which the former Prime Minister of the country was involved, to give to the world a impression, a message that all possible.
کسوری صاحب جب آپ یہ بات کہہ رہے ہیں نا کہ this was done to give to the world an impression, the minute you say that destroys your case. Why should we give to the world an impression?
Actually, we are
ہمارے لیے impression بناتے نہیں, sorry, ٹھہریے نا. If the whole purpose was to give to the world an impression,
And the world has condemned you for this.
یہ کیا بات ہوئی ہے؟ یہ تو قانون پاکستان کا لوگوں کو امپریشن دینے کے لیے تو نہیں کرتے نا فیصلے کہ دنیا کیا کہے گی. بھائی دنیا جو مرضی کہے.
دنیا نے جو کہا,
لیگل اور کوئی.
Then I traveled, see, I traveled to London,
legal baat.
to New York,
let's come to
America, and I just one of the top universities of the world where I explained the nitty-gritty of this case.
Learned Counsel, please, any other legal issue which you want to raise, you've heard.
جو ہے
وہ ہم نے پڑھ لیا اور
یہ ہو گیا. یہ جو ہے اپنا
ایشو کیا ہے جو آپ سمجھتے ہیں جو ان نے ایڈریس کی ہے, جو آپ اس کو رسپونڈ کرنا چاہتے ہیں؟
ایشو دیکھیں جی ایشو یہ ہے کہ prosecution produced me as for the motive, you see.
Were the other occupants of the car produced as witnesses?
Ji?
Were the other occupants of the car produced as witnesses?
No, see,
Why?
ہماری وی آر ویری کنونشنل فیملیز ہماری وومنز عدالتوں میں نہیں جاتی ہیں.
نہیں دیکھیں یو آر ایز گڈ اے witness as they are.
لیکن
the only thing
اچھا یہاں یہ تھا کسی مرزا قصوری نو eye witness account is given by me and
they may have seen something.
Inspector Ghulam Hussain.
They may have seen something.
See, Ghulam Hussain who was on the spot.
آپ نے دیکھا تھا اس کو؟
جی
آپ نے دیکھا تھا اس کو؟
آپ کی اسٹیٹمنٹ میں تو ہے
آپ نے دیکھا تھا غلام حسین کو شوٹ کرتے ہوئے؟
وہ تو دیکھا نا جی اس کا کیس یہی ہے نا پروسیکیوشن کا کہ ہی واز دیئر.
آپ نے تو نہیں دیکھا نا؟
میں نے کہاں دیکھنا جی میرے کو مامے کا بیٹا تھوڑی سا
وہ اٹارنی جنرل آ گئے کیا؟ because we can't wait. کچھ آپ کو بات کرنا ہے تو ہم آپ کا قصوری صاحب آپ کا تھینک یو فار.
نہیں میں سر میں
جی بتائیں
موٹیو پڑھنا ہے اسی.
جی بتائیں موٹیو تو ہم کر چکے ہیں.
نہیں موٹیو تو آپ نے دیکھا ہی نہیں.
دیکھیے ہم دیکھیں فار دا سیک آف آرگیومنٹ لیٹس پٹ دس.
جی
motive follows the act. I may have a motive in my head to kill 10 people. I may never do it. ٹھیک ہے, I can't be convicted for having something in my head. ٹھیک ہے, so first of all the act, motive کی بات ہم جا ہی نہیں رہے.
You are so kind enough to listen to me that.
نہیں تو آپ ہمیں جو ایکٹ
پڑھ لیں ذرا. یہ میری
نہیں ضرور پڑھیں گے.
This is my speech at the floor of the house. and یہ ججمنٹ کے اندر اس کا ذکر ہے.
اچھا پھر اگر یہ بات آتی ہے تو آرٹیکل 66 پہلے پڑھیے آئین کا.
جی
آرٹیکل 66 پڑھیے آئین کا. یہ تو آپ پھر خراب کر رہے ہیں اپنا کیس.
یہ نہ کریں.
66 پڑھیں. یہ آپ آرٹیکل 66 پڑھیں گے وہ تو کنسیڈر ہی نہیں ہم کر سکتے جو فلور آف دا ہاؤس پہ ہے.
جی
آپ دیکھ لیں نا آرٹیکل 66 آئین کا. آپ وہ یو آر فاؤنڈنگ ممبر سائن.
جی اس میں آرٹیکل 66 ہے.
پڑھ لیں.
مجھے پتا ہے جی میں ون آف دی فاؤنڈنگ فادر آف پاکستان کانسٹیٹیوشن اینڈ only one living founding father of Pakistan constitution. I played a very major role in the preparation of constitution because of my legal background.
کہہ رہے ہیں نا پڑھ لینا.
یہ رہنے دیں, یہ آپ یہ پوائنٹ نہ کریں, اگلا پوائنٹ کریں.
چلے میں دیتے ہیں
یہ آپ کو فائدے والی پوائنٹ.
یہ اب آ جائیے جی کانسٹیٹیوشنل پر میٹر پر.
کس پوائنٹ پہ
یہ کانسٹیٹیوشن اس کا کہ whether this honorable court can listen to this.
186. Yes.
Number one, that Article 143 of the Indian Constitution is identical with Article 186 of the پاکستان کانسٹیٹیوشن.
یہ مخدوم علی خان صاحب نے بتا دیا ہمیں.
جی
نہیں یہ بات چھوڑیں, مخدوم علی خان صاحب کر چکے ہیں.
اچھا چلیں میں آگے چاہ رہتا ہوں. دیٹ this is Supreme Court of India AIR 1992 page 522 that close and past transaction cannot be reopened since the law believes in the finality of litigation.
Agree with you.
See, that the constitutional engineering by filing instant review before the Supreme Court will reshape, modify the Constitution. Hence the Constitution will have to be rewritten because Supreme Court is not lawmaking body. That the President is empowered to refer any matter or question to the Supreme Court for its opinion, but subject to the condition that the matter should be live issue and not dead issue. Besides, the issue must be referred by the sitting President of the relevant period, AIR 1992 Supreme Court of India 52. That the criminal case in which Supreme Court has given its final verdict in exercise of its jurisdiction under Article 185, 188, review of the Constitution cannot be reopened through indirect manner by exercising its jurisdiction under Article 186, that the then President Zardari was an interested party, and it was not appropriate for him to refer his father-in-law case for an advice of the Supreme Court under Article 186 of the Constitution, particularly so on the dead and settled issue, 45 years old, in which Mr. Bhutto was sentenced to death. That the Supreme Court of Pakistan should avoid any adverse judgment or advice on the judicial conduct of the senior and distinguished judges of the past who are dead and cannot defend themselves, because this will open up Pandora box for the present judges also. Thus, it will adversely affect the dignity and respect of the Supreme Court in the eyes of people of Pakistan. That the sole object of this reference is to remove stigma of conviction as a murder which adversely affect deceased Zade Bhutto's reputation in particular and PVP generally. It is not the constitutional obligation of the court to remove stigma of the family in exercise of jurisdiction under Article 186 of the Constitution. Sorry, sir. Reopening of the decided criminal case emerging from a prompt FIR and 41 witnesses in support of the prosecution is not permissible in the eye of law and constitution, particularly so when the convict has availed the jurisdiction of this honorable court under Article 185 and 188 of the Constitution. And that the people of Pakistan are questioning the Supreme Court of Pakistan, is not taking up Model Town murder case and Benazir murder case, which are current and pending, thus awaiting for justice to be done. That the Supreme Court of Pakistan has full constitutional jurisdiction: direct, suo motu under Article 184 of the Constitution, appellate jurisdiction under 185, advisory jurisdiction 188, and review jurisdiction under Article 188 of the Constitution. Mr. Bhutto availed two jurisdiction of this honorable court under Article 185 and 188. Hence, this case cannot be reopened in exercise of its jurisdiction by the Supreme Court under Article 186. That the Supreme Court judgment under Article 185 and 188 acts as a res judicata, thus cannot be reopened under Article 186 of the Constitution. That under Order 26, Rule 9 of the Supreme Court, Rules 1980, second review is not permissible in the eye of law. That suppose the Supreme Court were to reopen Bhutto case exercising its jurisdiction under Article 186 of the Constitution, it will open up floodgate of litigation. Thus, court will be inundated in the tsunami of cases. That the present reference is neither of a public importance nor there is any question of law is involved. If at all it is a question, it may be the question regarding the stigma of the family. Hence, the court have no jurisdiction to wash out the stigma of any individual through Article 186 of the Constitution. That reference in hand suffer from huge technical error, as no question of law has either been raised regarding which the advisory opinion of Honorable Court has been sought. See, these are the law points which I would very humbly request this Honorable Court that before proceeding further, because this is a bridge, admissibility, you see, and I don't think we have yet crossed the bridge of admissibility, and these are the impediments, you see, in the way of crossing the bridge. These are the impediments, you see, and that court must look into it, because otherwise there will be scores of cases tomorrow, see, the symbol case, party symbol case will also come up, see, and we wouldn't like that kind of activity to continue in this country, because that will lower the dignity and the reputation of this honorable court, where we get the justice and fair play. Thank you very much.
कसूरी साहब एक सवाल का जवाब दे। ये जजमेंट आपकी इतनी माशाल्लाह प्रैक्टिस है, काफी अरसे की है,
मेरे जी कुछ 60 साल
60 साल ये सारे टेन्योर में कभी आपने इस जजमेंट को एज ए रेफरेंस किसी कोर्ट में पेश किया, इसको रिलाई किया?
मैं करता हूँ जी, मुझे तो कोई नहीं ना करता, मैं तो करता हूँ।
किसी ने एक्सेप्ट की किसी कोर्ट?
मैं तो करता हूँ जी, क्यों नहीं करते?
किसी कोर्ट ने एक्सेप्ट किया?
बिल्कुल करते, क्यों नहीं करते जी?
देखिए कसूरी साहब,
ये कोई पटियाला सुप्रीम कोर्ट ने नहीं फैसला किया या
नहीं कसूरी साहब, देखिए we are very grateful for you, you are a witness to history, but the matter before us was a presidential reference, and as far as senior counsel making uncalled for side remarks of other cases before us, I don't think that was appropriate. You may want to reflect upon it. If you don't want to reflect upon it, don't do. ठीक है? Making of speeches, that's the forum, or the media's forum. Here we are concerned with a presidential reference. Whether we like it or not, we can't disregard it. We will have hearing it because it was lay buried and it's been brought up. It was brought up earlier. You participated in the hearings, and we are doing sometimes duties we do. We are not even happy with doing them. Sometimes they're painful duties. There is a political aspect to matters. The point is, one point which we should all realize is how long will we tear the nation apart from within. We don't need enemies. We have enough enemies of our own to destroy this country. We can't sit on a table and talk about matters. We can't talk reasonably. You are a senior counsel, you're making side remarks. Fine, we don't like a particular judgment, do whatever you want to do with it. You know the legal course. I found it very unbecoming of a senior counsel to do that. I respect you always. I continue to respect you. This is not just your case, it's a matter of our history as well. There must come a point in time when we must say enough is enough, let truth prevail. We all have committed mistakes. I mean, everybody says the other one is black and I'm white, without ever raising a finger on themselves. I, for one, agree with some of your political remarks. Idhar hum, udhar tum. I don't think they may have been appropriate at all. But we're not dealing with that aspect. That's a matter for politicians and historians. We're dealing with advisory jurisdiction, which you, people like you who framed the Constitution, granted us. We did not want this advisory jurisdiction. You gave us. Now it has come, it says shall do it. So we have to do it, whether we like it or not. So let's always respect each other, and not just come and say, capture a headline tomorrow and make some statement. આજકાલ the fashion is the courts cannot respond to anything. Any person, Tom, Dick or Harry, will go outside and make a statement. I mean, even there are elements, but there's no proof, no substance, they make allegations. If there is something, please produce it. Otherwise, don't. I mean, it's just a question of hits, numbers game, how much hits you earn. Let's forget this. Let's make this a proper, decent country to live in. We are doing a duty. You're doing yours. We are very grateful to you. We never say anything to you about your conduct. We are just conducting a case. So please don't mind if we've said anything. And so far, it has all been very amiable. Maybe, yes, of course, it was father. We feel for him. I mean, your Nana was my father's in the working committee together. I did not know he was your Nana. I just learnt of it. Now, Attorney General, can't wait anymore. If you want to say something, please do so. We will then,
Few submissions, my lord.
Sir, the dignity and
I don't want you to respond.
Sir, the dignity and respect of this court is very dear to me, and whatever I said just to build up my case. You see, I had no animus against anybody, and I'm here only to assist the court, and it is for the court to decide the future course of action under the Constitution. Thank you very much, sir. I'm so grateful that you have listened to me for such a...
and thank you for the book. We'll look into it also.
That's an interesting book, because that will give you the history. It's a most checkered history of this
Very
country.
few people in Pakistan write books, and I think anyone who writes a book in Pakistan should be commended.
Very kind of you, Siti.
Ji.
Thank you.
Thank you.
God bless you.
Ji, Chaudhary
God
Sahab,
bless
do you want to add anything?
My lord, just summing it up, and I would
वो
just.
आप हमें डॉक्यूमेंट दे
My
दीजिएगा.
lord, वो मैं दे देता हूँ. My lord, सिर्फ एक paragraph I would like to read, and that is interesting. My lord, this is CMA 66. This is a written submission by Miss Reema Umar, और उसमें उन्होंने प्रोसीजरल रिक्वायरमेंट की जो नॉन फुलफिलमेंट है उसके ऊपर उन्होंने जो हिस्टोरियंस ने विज़ भट्टोस केस लिखा है वो उन्होंने कोटेशंस दी हैं. तो दैट्स वेरी इंपॉर्टेंट जी.
Want us to read that? CMA 66.
CMA 66
By amicus, we had appointed an amicus.
माय लॉर्ड्स.
जी.
और उनका अगर पेज 7 टाइप रिटन पेज 7 नीचे बॉटम पे हैं जी पेज नंबरिंग.
You want to read it? Short passage में लंबा.
सिर्फ एक पैराग्राफ
पढ़ लें.
The violation.
Which page?
My lord.
7. जी.
The violation of these procedural requirements in the trial are documented by many scholars as evidence of the bias and partiality of the court. To substantiate the claim that Bhutto's conviction was a miscarriage of justice, America's former Attorney General Ramsey Clark wrote at the time that Bhutto had been twice the victim of unfair judicial proceedings and would be the victim of legalized political murder. Historian Frank McLean condemned the partiality in proceeding of the case, saying Bhutto could hope for neither due process nor a fair hearing, and the Chief Justice Anwarul Haq presided over appeal is perhaps the greatest injustice in this case. The historian Ian Talbot wrote that the proceeding of the case revealed that Dya was set on Zulfikar Ali Bhutto's judicial murder. The legal historian Paula Newberg writes that Bhutto conviction caused profound public dismay with the civil courts for years after their verdict. It was assumed the military government had found a way to eliminate its most profound opposition by influencing the justices and judicial decision. Thus, the viewpoint across scholars and observers writing on the trial are largely unanimous in declaring the trial to be a miscarriage of justice. My lord, one thing, your lordship, we also adopt the arguments which were made by Justice Manzoor Malak, my lord. I have known him as a very
ये 66 से पढ़ा आपने?
My lord,
it is not by Reema, it is by Yasser Qureshi.
My lord, या ऊपर ये लिखा हुआ है
65 है उनकी.
ये 66 by Yasser Qureshi.
हमारे पास जो कॉपी आई उसके ऊपर वो लिखा हुआ है.
वो 66 है शायद.
ये आप ठीक कह रहे हैं, मेरे पास भी यही है, लेकिन अगर आप इनका पहला पेज देखें, open it and you'll see
करेक्शन हो गई थी.
वो 66 में है. रीमा उमर की जो पेपर बुक है वो दैट इज CMA 66.
नहीं 66 यासर कुरैशी की.
पेज गलत लग गया.
ऊपर पेज गलत लग गया. माय अपॉलॉजीज.
दैट्स फाइन.
माय लॉर्ड, सिर्फ एक चीज जो है, एक माय लॉर्ड जो there has been, this trial was conducted on an investigation which was purely totally illegal. Basis of that investigation, there was no judicial order which could have permitted, and without any judicial order, no investigation in a case which has been closed by a magistrate could have been done. So the entire edifice of this case is built on investigation which is illegal. One thing जो my lord जो उसका है 374 वाला, उसका आंसर my lord सिर्फ 185 आर्टिकल 185 में है. Probably it says कि जी appeal lies to the Supreme Court when a case is withdrawn by the High Court for trial.
Sorry, say that again.
My lord, Article 185 says that a direct appeal lies to the Supreme Court when a High Court withdraws a case for trial before itself, my lord. And ये
रीजनल
185
जुरिस्डिक्शन में अगर वो करेगी तो उसके खिलाफ अपील जो है सुप्रीम कोर्ट में आएगी,
2D में है।
लेकिन रेफरेंस तो कहीं भी नहीं है ना।
रेफरेंस नहीं है माय लॉर्ड,
असल बात तो ये है।
रेफरेंस नहीं है, दिस इज वन राइट जो है वो
उसमें 374 में लिखा है कि अगर रेफरेंस वो नहीं होगा तो एग्जीक्यूशन नहीं होगा।
एग्जीक्यूशन
ये कह रहे हैं।
ये बिल्कुल ठीक, ये दुरुस्त है मानो।
जी साहब, आपकी बात से अगर मैं समझाऊं, ये आप समझ इसको एडमिट करते हैं कि इस केस में इन्वेस्टिगेशन स्टेज पे और जुडिशियल स्टेज पे
Miscarriage of justice
सरकार की तरफ से इंटरफेरेंस थी।
माय लॉर्ड, इट सीम्स माय लॉर्ड के
अगर ऐसी थी क्या, तो क्या गवर्नमेंट कोई इरादा रखती है कि ये इंटरफेरेंस खत्म की जाए, उसके लिए कोई मैकेनिज्म में जाए, इंडिपेंडेंस ऑफ जुडिशरी और इंडिपेंडेंस ऑफ इन्वेस्टिगेशन?
ऑफ कोर्स माय लॉर्ड, वो
क्या प्लान है ये भी आप बताओ।
वो तो हमारा जी, हम तो इंडिपेंडेंस ऑफ जुडिशरी के पहले दिन से दाई रहे हैं और हमेशा
क्या
इसके
स्टेप, उसके लिए क्या स्टेप्स ले रही है आप बताएं।
माय लॉर्ड, अब नई गवर्नमेंट हैज बीन फॉर्म जी, वो उसके जैसे ही जो भी आता है वो उस पे
या इस रेफरेंस में मशवरा दे।
माय लॉर्ड इसके ऊपर तो रेफरेंस
कमेंट्स आती जाती रहती हैं, हम अपना काम करें, दूसरों को अपने काम करने दें बेहतरीन तरीके से। तो थैंक यू। वी विल व्हाट वी विल डू इज मे बी नॉट टुडे बट वन ऑफ द honorable members will be retiring soon, so it may not be sufficient time to come up with a detailed opinion. We may announce a short opinion. I don't know when we'll have a meeting and discussion, so we may do that. So everybody, we thank everyone for their assistance.
Your Lordship had directed to pose certain questions. I am filing the answers to those questions, and my Lord, Justice Yahya Afridi had directed that the transcript be filed with highlighting. I'm doing that today.
Thank you.
And the thing about the bias which was not addressed,
I must commend all first of all, our thanks to the amicus, and I must commend all the counsel who, each one of you conducted the case admirably and very professionally. And we will maybe convene again for a short time, not today, and another day after we have discussed it, to announce an